to you too. I can see you and I can hear you. The 5 justices are now present. Thank you.
Susanna, I send IM to the Judge Gish, the start court. Susanna, I send IM to the Judge Gish, start court.
Justice Gish, you may proceed.
Thank you. I was waiting for the signal. Thank you, Frank. This session of the Appellate Division is now open. Welcome to the first session of this new year. My colleagues and I wish you all a happy new year before we begin. Let me proceed with the calendar call. I'm going to confirm the times that have been allotted to you for argument. You need not answer the call since we have noted your appearances previously. The first case, People versus Skeet. Appellant will have 3 and 1 for rebuttal. Respondent will have 3 minutes. Rodriguez versus City of New York. Appellant will have 5 and 2 for rebuttal. Respondent will have 5 minutes for argument. In the matter of the G children will be submitted. Resurgence Asset versus Gitamol. The appellant will have 5 and 2. The respondent will have 5 minutes for argument. Wilson versus Wilson. The appellant will have 4 and 1 minute for rebuttal, 4 minutes for the respondent to argue. People versus Acosta. The appellant will have 5 and 2 minutes rebuttal. The respondent will have 5 minutes. Ricardi versus State of New York. The appellant will have 5 minutes and 2 for rebuttal. The respondent will have 5 minutes. Feuerman versus Marriott International. The appellant will have 4 minutes and 1 for rebuttal. The respondent will have 4 minutes. Carmel versus Young Men's Women's Association. The appellant will have 4 and 1 for rebuttal. The respondent will have 4. People versus Funes will be submitted. Levovsky versus Levovsky, 5 minutes and 2 for rebuttal for the appellant, 5 minutes for respondent. Rustic versus 124 Ridge. Do we have the respondent? In which case the appellant is the only one appearing. You'll have 4 minutes for argument. People versus Contreras is submitted. Queeros versus Memorial Hospital, 5 and 2 for the appellant, 5 for the respondent. Cooper versus MTA, 4 and 1 for the appellant, 4 for the respondent. People versus Lawrence Parker, 3 and 1 in rebuttal for the appellant, 3 for the respondent. Kenyan and Kenyan versus Sight and Sound Technologies, 6 and 2 for the appellant, 6 for the respondent. Hancock Tire versus Samsung Fire and Marine will be submitted. The first case up for argument, People versus Skeet.
Good afternoon. Allison Kale on behalf of defendant appellant Quinn Skeet. Quinn's sentence should be reduced given his age, lack of criminal history, and the responsibility that he took for his actions. He was just 20 years old when this incident occurred, and although it was serious, he was reacting to the destruction of his car that he lived out of at the time because he was homeless. It was his first felony offense and his first meaningful interaction with the criminal legal system. As his counsel below noted, Quinn wanted to and did take responsibility for those actions by pleading guilty. He was offered a today-only offer, and he took it. But his current sentence requires him to spend nearly the entire amount of time he has been alive, 16 years, either incarcerated or in supervision. A reduction of his sentence is warranted here. Society's interests are better served by a lower sentence that recognizes Quinn's age, his ability to rehabilitate himself as he ages, develops, and grows.
I'm sorry, counsel, you said 16 years. You're counting the 5 years post-release supervision because he was sentenced to 11 years incarceration. Is that correct?
Yes, Your Honor. I said 16 years of incarceration and supervision that he'll be under. He was sentenced to an 11-year incarceration sentence.
Right,
and
that's
then
what I
5 years
thought.
post-release.
And this was based upon his firing a gun, and he shot how many individuals?
It was one individual, Your Honor.
He shot one individual, and he shot how many times?
2 times, and
then he proceeded to pistol whip the individual after shooting that individual twice. Is that correct?
That's correct, Your Honor. And while it was a serious incident, Quinn, again, is someone who is in his 20s. This court has reduced sentences for similar offenses to as low as the minimum 5 years, between 7 and 10 years of firm sentences. And in addition, as I mentioned, his post-release supervision sentence was double the minimum that he could have received here.
And these individuals, I'm sorry, were these individuals known to each other, or were they strangers?
I don't believe that that's noted in the record anywhere, Your Honor.
But the individual, this was someone who was standing near his vehicle?
Was destroying his vehicle that he lived out of at that time because he was essentially homeless. And it was a serious and juvenile response to that, which Quinn has taken responsibility for.
What type of response did you say this was? I'm sorry, I didn't hear you.
Oh, I said it was a serious and juvenile response to that destruction. But he took responsibility for that and has always taken responsibility for that when he pleaded guilty, and is now going to be sentenced and has a sentence of 11 years and 5 years post-release supervision that we're asking this court to reduce.
Thank you. We'll hear from the people.
Good afternoon, and may it please the court. Catherine Murata for the people. Defendant's sentence is fair and appropriate for several reasons. First, Mr. Skeet received a sentence well below the maximum. He pled guilty to 2 counts of attempted murder in the 2nd degree, which exposed him to a maximum prison term of 25 years. Defendant's 11-year prison sentence demonstrates the benefit that he received from pleading guilty. Second, defendant's crime was serious and violent. Mr. Skeet shot the stranger victim in the legs several times and then repeatedly struck him in the head with his gun, causing the victim to be hospitalized for a month and undergo 2 surgeries.
Counselor, not that it would, well, I'm not saying, is it correct that this individual was somehow vandalizing the vehicle, which was the defendant's home?
At the point at which defendant shot victim, it was unclear. He was standing across the street from the car when defendant shot at him.
How many people did this defendant shoot at?
He shot in the direction of the car, and he also shot at the victim who was standing on the same side of the street as defendant. So he injured 1 person.
He injured 1, but he shot in the direction of the car where there was another person standing.
Judge, I think that the only person standing was on the same side of the street as the defendant. He shot in the direction of the car because the car was vandalized.
Was there anyone near the car when he shot in the direction of the car is what I want to know.
I don't believe so. One second. Next, the factors that defense counsel cites here, particularly defendant's age and his lack of criminal history, were known to the sentencing court when negotiating this agreed upon sentence. In fact, Justice Bibben, who was the judge at the plea proceeding, specifically noted that she had considered the mitigation that defense counsel had proposed, particularly defendant's youth, but noted that this was a serious case and quite a strong one. So in light of with that consideration, the sentencing court had considered his youth and yet sentenced him to life.
Counselor, can you tell me, are you taking any position, or are the people taking any position about the validity of the waiver of appeal?
Judge, although the people do not concede that defendant's waiver of appeal is open to challenge, assuming that it is invalid, we hold that defendant's excessive sentence claim is meritless. If there are no further questions, we ask that you affirm defendant's sentence. Thank you.
Any questions, colleagues? All right, rebuttal?
The waiver here was not valid. It's been found invalid in a recent case with a very similar colloquy from the same justice. The waiver conflated both the trial and the appellate court rights. And again, considering Quinn's age and criminal history and his understanding of the proceedings was limited. So the court could find that this waiver is invalid and reach the excessive sentence claim. And just want to reiterate again that the post-release supervision part of his sentence as well could be reduced by this court, where the minimum here was 2.5 years. He received 5, with the Less is More Act being passed and signed by the governor. It's well recognized in the state that these long sentences are not necessary and don't serve society's interests. So we ask that you reduce Quinn's sentence. Thank you.
Thank you. Thank you both. Right, the next case is Rodriguez versus City of New York.
Good afternoon, Your Honor. May it please the court. William Pager on behalf of Yadi Rodriguez, the appellant. Your Honors, can you hear me okay?
We can.
Okay, excellent. Thank you. Okay, Your Honors, as you're aware, this appeal stems from an incident where my client, a teenage student of the school, Yadi Rodriguez, had been assaulted by another student in school. The student who assaulted her, one Sharice Andrini, we submit, is a teenager with a past history of violence that the school had been aware of, which is evident from the record. I'm looking at the court order that we are appealing from, and the court order is just not consistent with what the record showed. The lower court said—
Can you explain to me what you base your statement on, that the school was aware of the assaulter child having a history of this kind of conduct?
Sure. In fact, Your Honor, actually, your question jives with my general point. The defendant, as a movant, had an obligation to demonstrate that the assailant had no prior history, and they utterly failed to do that. They were obligated through.
They did. Well, that's not exactly true. I mean, there were depositions from people who were involved in managing the case, and they indicated they were unaware of any prior conduct that would have put them on notice that there would have been an incident between your client and the alleged assaulter.
Well, I would submit, Your Honor, that the answers given by the dean were very carefully phrased. He said he didn't know anything about it, and he basically denied knowledge, which is not the same
So,
thing.
counsel, where in the record was there anything that the school had any notice of any issues with the child?
My client put in an affidavit which clarified her EBT testimony.
Prior
Sure.
to her affidavit, didn't she testify that she had in fact never had any problems with this individual who she got into a fight with?
Well, the question was never posed to her whether anybody had had a problem.
Well, how would
would
she? But counsel, I'm sorry, you still haven't responded to my question.
Sure.
Where in the record is there anything that the school had any notice of violence or assaultive behavior by this child? My
Okay.
understanding was that in the record there was testimony that there was an absentee problem with the child in terms of her attending classes, but nothing about her having any assaulted or her exhibiting any assaultive behavior with anyone at the school.
If you're speaking of evidence that came directly from the school, I'll concede they did not confess that this child did have it.
Okay, so where is there evidence of? Okay, well, if there's nothing from the school, how is there notice to the school?
My client describes 3 separate incidents that would have been in the disciplinary record. My client describes in her affidavit 3 incidents, one involving a teacher where this assailant had been removed by security to the dean. My client describes 2 separate students by name who had been assaulted by the same assailant, Sharice Andrini. And that presumably, since on each occasion she had been removed by security and taken to the dean, presumably that would be a record that would be inside her disciplinary record, which has amazingly gone missing. So there is in the record.
Well, it wasn't gone missing. I thought the indication was that she was transferred to another school and that the records follow her along. I don't know if gone missing is exactly the right characterization.
That's my characterization, Your Honor. The fact of the matter is that having been placed on notice of this lawsuit since almost immediately after this lawsuit occurred, the school should have known or at least attempted to get these disciplinary records, but instead, rather than A, keeping a record, B, handing it over to counsel, C, getting her records back from the school where these disciplinary records supposedly had followed her, they did none of it.
Yeah, okay, here's another point. Other than the notice point, from there was a security guard who did intervene, correct?
Correct.
All right, and to your best look at the record, how long did it take between the time of the assaultive behavior until the security guard intervened? How long did that take?
It was probably not very long, but according to the Court of Appeals and according to this court, we're not to look at the amount, the quickness, the speed of the punch and the speed of the response, but we're to look at all of the circumstances and looking.
Well, isn't that one of the circumstances?
Oh, it's one.
If an earlier intervention could not have stopped this, if it was a sudden and spontaneous situation where the security guard intervened as quick as was reasonably possible, isn't that a separate basis on which your case is problematic?
No, Your Honor, respectfully, I would submit that it wouldn't be. Number one, if, as we believe, this individual student was a problem student, that issue should have been raised and taken care of long before this incident came to occur. Number
But
one.
counsel, even assuming again that she was a quote unquote problem student, she was not a problem student towards your client. Your client specifically stated that there had not been any conflicts or any issues with her. And in fact, I think at some point in time, I don't know if she regarded her as a friend, but she certainly did not regard her as an enemy. And she did not know of any issues between the two. So if we have the fact that we have no conflicts with your client and this child, and we have the fact that it seemed to have been spontaneous, that as soon as that first blow was struck by the child towards your client, the security guard immediately intervened. I'm not sure how that would cause liability on the part of the school.
Very well. So if you take a look at the deposition testimony of the security guard, Mr. Dunbar, he says, and so does the dean, that they're obligated to have two individuals during this dismissal time, which this court and the Court of Appeals has designated as a very dangerous time where incidents like this could happen. So rather than two individuals, which would and could serve as preventative measures, as a way of cautioning students not to engage in kind of violent behavior, you have a single security guard posted and watching.
So your argument is that if there had been a second security officer, then the child would not have struck your client?
Perhaps. The more security, the less opportunity for a violent act. So my position is that there's at least two bases for finding liability on the school. Number one, the school admits that there was insufficient security. Everybody agrees that there's supposed to be two security persons per floor. And everybody admits that on this third floor, there's only one. In fact, Mr. Dunbar says, I'm not even sure if there's any other security in the building because the security was going through changes. So you have a school.
Well, that wouldn't have made a difference because the incident occurred on one floor. So I don't think that really, it doesn't make a difference. I'm not sure having two security guards makes a difference either on the third floor, but certainly what they had on the second and first floor couldn't have impacted this accident at all.
Perhaps not, Your Honor. If the
no, not perhaps or perhaps
well,
not.
I'll tell
I think
you
you have to concede that point. But I'm going to ask you to wrap up your thought because you're out of time, and we'll hear from the other side.
Sure. My very final thought on this, Your Honor, is the defendants had an obligation to bring forth evidence to demonstrate that they lacked prior notice of prior violent propensities. They did not do that. They had an obligation to demonstrate that they had sufficient security on the floor. They did not do that. The lower court makes general statements that student had no documented history of physically violent behavior, which is completely untrue, and there's no evidence to that. The lower court makes statement that the Sharice Andrini has never been subject to disciplinary action, which is completely untrue. We don't know that. The defendants did not meet their initial burden on summary judgment.
We understand that argument. Thank you. Let's hear from the other side.
May it please the court, excuse me, Glenn Kaminsky with firm Amity Demers McManus, counsel for the respondents. Respectfully, we ask this court to affirm the decision, the well-reasoned decision of the Supreme Court.
So counsel, why don't we have any records from the, as to the child, as to whether there were any prior disciplinary procedures, suspensions, et cetera?
As was indicated in the argument, that those records went with Sharice when she transferred to Pathways in the normal custom and practice as submitted by the affidavit of Hector Rodriguez. So
weren't they obtainable? I mean, so they transferred with her. It's not like they disappeared into the ether. Why couldn't you produce them? Still the same kind of educational system here.
Well,
right?
it's No, it's a different school. We're a charter school. It's not a city school. And I would put that question right to the plaintiff themselves. The plaintiff had every opportunity to do this as well. Let's remember, the demand for these records wasn't made until 6 years after the incident and after the deposition testimony was taken, which indicated that the records were gone when they transferred. So you're putting an undue burden on my charter school, where the plaintiff themselves, if they thought these records were truly dispositive or in any way controlling, they could have found them themselves. They chose not to do that. But what we do have is the deposition testimony of the school and the security guard, which is unequivocated that they never saw Sharice ever threaten the plaintiff before, or any other student.
And they knew her. They knew the kids.
And they knew her.
It wasn't a school where these were strangers to them, right?
Absolutely.
They would have reason to know a little bit about the children in this particular school.
Yes, Mr. Dunbar testified that Sharice was full of energy, not that she was violent or in some way a problem. There's absolutely nothing, and the court got this absolutely correct, that there's no evidence at all of any prior incidents involving Sharice of violent behavior, is certainly not of the type here. What we really have is plaintiff's own self-serving post-EBT, post-summary judgment affidavit, where suddenly she remembers that, well, this Melissa and this other student, well, in the cafeteria some months, but we don't know how many months prior, there was an incident. But the incident isn't like in kind of what we have involving the plaintiff. One, we're in the cafeteria. Two, we see that if we are to believe the plaintiff, that there was yelling, cursing, threatening before there was any kind of confrontation. There was not this sudden violent attack without words, pulling the hair and then striking, which is alleged to have occurred here. And if it's not like in kind, there's not that notice of a sufficiently similar situation that would put us on notice of a dangerous condition.
So how do you respond to your adversary's argument concerning the lack of security, or at least perhaps you're not adhering to what the security plan was?
Even if we accept that there was only Mr. Dunbar, and Mr. Dunbar testifies, he's the only guy on the floor at the time. And Mr. Payne testifies that there would usually be two people on the floor. But even so, this attack was so spontaneous, so sudden, that no level of supervision could have controlled it. And in fact, what we hear from Mr. Dunbar is it's over in seconds, and the plaintiff herself agrees with that, testifying at page 95 of the record. Everything happened so fast. So it's not a situation where you look at all the circumstances, because there's not this yelling. There's not this prior animosity. There's not any kind of indication that this confrontation is going to take place. And the court below properly granted summary judgment for the reason they stated, but also, as Justice Gish had indicated, that as a separate independent reason, the spontaneous attack, no level of security, and it wouldn't be the proximate cause.
Thank you. We're going to hear rebuttal from your adversary. Mr. Pager?
Thank you, Your Honor. Just a couple of points. Number one, with respect to animosity, Your Honor, you will see in the record, we've attached Facebook posts from Miss Andrini, who is identified as Sharice Pacino, I guess assuming the name of actor who plays violent.
Let me stop you there for a moment. Sure. I mean, because I did see that in the papers, and I'm thinking to myself, would this school have an obligation to search through a child's Facebook records, particularly when the child is using an assumed name? I mean, how would that constitute notice to the school?
It does not. I'm using it. I'm referencing for a completely different reason. I'm telling the court that there was obviously animosity, at least going one way, from Ms. Andrini towards my client, that my client was not aware of. This is not to say that there's notice based on this to the school. Notice based to the school is based on Ms. Andrini's prior violent acts towards at least 2 students and one teacher, which presumably will be memorialized in disciplinary records, and an incident report, Your Honor, by the way, which is similarly missing. And
so did your client, she claims that she saw this Facebook post, where it's totally different. It's Sharice Pacino.
right.
Did she report this to the school? Does she tell anyone at the school? Does she tell Dunbar or Payne or anyone about this Facebook post?
I don't think she expected to be assaulted, Your Honor. I think that the burden is not on her. The school should have been aware of Ms. Andrini's prior violent tendencies based on the incidents that already occurred. They already knew that she was a bad guy, which you could tell, Your Honor, from the fact that right after this incident, she's suspended and then she's removed from the school.
But we don't know why. I mean, it could be to
Could have been
separate the
based on
two.
this-
I mean, you know, that has to
Anything possible.
separate them.
Well, this incident was pretty bad in and of itself, might be the reason that they suspended her.
Your Honor, one student gets suspended and exits the school, and my client does not. That should be indicative of something. And again, if there are any inferences to be had, there should be in favor of my client, the non-movement. So I would think that there were 2 court orders, and I wouldn't think, I know for a fact that there were 2 court orders.
I'm going to ask you to wrap up. This is rebuttal. And your
Sure.
time is up. And we
Very
have
well.
a very busy calendar today. It's not that I don't want you to have more time.
Understood, Your Honor.
So-
Just one final sentence. There were 2 court orders that directed the defendants, 2 separate court orders and a stipulation that directed the defendants to produce records. They didn't. That should have been enough to deny summary judgment. And I'll leave it at that, Your Honor, and I thank you for the time.
Thank you. Thank you both.
Thank you, Your Honor.
The next case for argument is Resurgence Asset versus Gitamol.
Yes, Your Honor. May it please the court. My name is Sean O'Brien. I represent the appellant Stephen Gitamol. Can the court hear me?
We can.
Excellent. We're seeking the reversal of the summary judgment order dismissing Mr. Gitamol's counterclaim. It's a counterclaim in which Mr. Gitamol seeks to recover profits.
We're familiar with it.
Oh.
Let me ask you a question. Let's get to the heart of this.
Sure.
So the agreement that the parties had indicated that the financial statements would be conclusive. Why doesn't that just end the story here? Why are we looking at whether the financial statements and the way they reported expenses, why are we looking at that as an issue here?
Sure, Your Honor, because the agreement also requires that the expenses allocated be reasonable. And that very argument was made both when we filed the motion to amend to assert the counterclaim, and Supreme Court Justice Singh rejected the argument. That argument was also made in the prior appeal of this matter, and this court rejected it. The fact is, the agreement says that the expenses need to be reasonable. It says the financials need to be provided to Mr. Gitamol so that he can examine them. And any other reading would suggest that RAM could actually provide false or unreasonable financials, and Mr. Gitamol would be bound by them. And that's, by the way, Your Honor, not even an argument at this point on this motion that RAM made, and I think it's because they knew that it was the law of the case to the contrary. And so what they tried to do was to say somehow there were difficulties in Mr. Gitamol proving his case, but I think as the record is clear and the court's ruling is clear, the lower court never even asked and certainly never determined whether RAM had come forward with undisputed proof proving that it had complied with the agreement. Mr. Friedman didn't even say that they complied with the agreement. He does not say that the expenses are reasonable. And Your Honor, we brought this claim, if you'll recall, and I know you're familiar with it, We got these records in discovery. We took the deposition of the CFO, who was there at the time, and we tried to see if he could explain if the expenses were reasonable or if the reallocation made sense. He could not do it. We then took the deposition of the head of the firm. He could not explain why these new expenses came in to wipe out my client's expenses. And then we're given a guy, Sam Friedman, who was not even at the firm, and he comes up with some explanations about how certain expenses went down. The simple fact is they never came forward with undisputed proof. The burden therefore never shifted to Mr. Gitamol. And on this record, it's quite obvious that new and unreasonable expenses were shifted and wiped out Mr. Gitamol's profits, thus making it, so taking away his main benefit under the agreement, Your Honor. And the court plainly put the burden on Mr. Gitamol. And finally, the point about an expert, we made the point in our brief. I don't believe the reasonableness of these expenses is probably amenable to summary judgment, but if you need an expert to prove that they were reasonable, well, then RAM had to come forward with that expert, and they didn't.
So in other words, from your point of view, since it was their motion for summary judgment to dismiss your counterclaim, their prima facie case had to include some proof of reasonableness of the expenses.
Certainly, for them to comply with this agreement, we filed a claim, right? The court granted us the right to file the claim and said we had stated a claim that the expenses were unreasonable. So we've satisfied our prima facie burden. In order for them to even shift the burden back on a motion for summary judgment, the movement needs to come forward with, as you know, undisputed proof demonstrating that they had complied with this agreement. That is, they had only allocated reasonable expenses. They don't even have a witness who says they complied with the agreement. They don't have a witness who says the expenses were reasonable, and thus the burden never shifted to us. But even if it had, and you look at the evidence they provided, the fact is no one can say these expenses are reasonable. They're new and they're unexplained, and they just happen to wipe out all of my client's profits. This case is going to go to trial, Your Honor, on other things, on the damages. We're asking that when it goes to trial, we're entitled to prove this case because RAM did not establish that it's entitled to judgment as a matter of law through undisputed proof. And if there are no further questions, I will wait for rebuttal.
Any questions, colleagues? Okay, thank you. All right, we'll hear from opposing counsel.
May it please the court, Barry Pollock on behalf of Resurgence Asset Management LLC, and I'll assume everyone can hear me unless I at least see hands waving or a comment or hear a comment made. My adversary must have misspoken because we did argue, just as the trial court found, that the word conclusive must be given meaning, as it's a fundamental rule.
Actually, Mr. Pollock, we can't hear you. You're on mute.
I don't know when I can't cut out, but I saw it all of a sudden. You heard me at the, I take it the court heard me.
We did. We heard you when you asked us to tell you. If
I wasn't even touching my computer, so I'll lean back if that's okay.
I will give you the benefit of that. Go ahead.
Thank you, Your Honor. So we did actually argue that the word conclusive must be given its ordinary meaning, or at least some meaning. And Mr. Gitamol's, we argue on page 14, this very point, right after quoting the trial court's finding that conclusive means conclusive. But we do give Mr. Gitamol the opportunity that makes sense there, which is if two people enter into a contract where they agree something in the future will be conclusive, there may be the opportunity for the party to say, wait a second, you wrote these financials, and I say this figuratively, in crayon and in bad faith. And he had a full opportunity in discovery to try to generate some type of a case. So what we introduced here was the agreement itself, the agreement that stated those unaudited financial statements would be conclusive. And we introduced the unaudited financial statements that cover that time period, along with an explanation of the calculation by the CFO, who stated a full foundation in his affidavit for relying on these records and putting them in. He was the CFO at the time of the motion for summary judgment. There was no motion to strike that affidavit. there was not even a notice to depose that CFO because the former CFO had been fully deposed and questioned on this very point. I think this is one of the most important points here because Mr. Friedman was the CFO at the time of the summary judgment motion. He describes the calculation and explains why it is that what indirect expenses are and why it is that as RAM is winding down, you'd see an increase in indirect expenses, which means the parent company is providing the services that used to take place at RAM by RAM employees. And that's the same exact thing Mr. Sivan said, the former CFO, at his deposition. This is on record pages 269 and 270. At some point, just as the claim was made here, we didn't argue anything about the word conclusive. In briefing, it was claimed that somehow Mr. Sivan and Mr. Friedman were inconsistent with one another. Not remotely. Mr. Sivan on record page 269, 270 also explained, while not every year has an exact 100% overlap, there are employees that provide services and nothing new and additional. He was asked questions about whether there was anything new and additional in the expenses and said he could not identify anything new and additional. And in fact, what you saw with things move from one bucket to another. But here's the final, I think, piece in the record that forecloses Mr. Gitamol's position. That's on record page 438 and 440. It's an email during the negotiations of the separation agreement. It's mid-August. The separation agreement was signed September 28th. It was dated September 28th, signed within a couple of days then. So 6 weeks before the separation agreement was signed, Mr. Gitamol is provided with draft financials for 2008 that broke out the same exact indirect expenses and showed them. So when Mr. Gitamol claims here on appeal that indirect expenses were never broken out until after he signed the agreement, that's just contradict. It's put in the briefs. It's not even speculative. It's just wrong. There's no factual offering by Mr. Gitamol to that effect. And in fact, his lawyer saw on his behalf indirect expenses broken out the same way they're broken out afterwards, the same way they're broken out year after year after year in these conclusive financials. That forecloses both the merits. This is a contract case, not a medical malpractice case where you might be dealing with tough causation issues. This is about the plain language of the agreement. The trial court did a thoughtful job, cited to the right case law, the proper summary judgment standards, recognized expressly, word for word, that the initial burden was on us, did not use the word possibly. I know we've been criticized in the reply brief because at one point we said possibly entitled to summary judgment, but that's just trying to be precise. We weren't asking for a new standard. We weren't quoting the standard. It's saying, look, we make a prima facie showing of our case. If there's nothing in rebuttal, we're entitled to summary judgment. And we have even more than that here because we have the word conclusive. And Mr. Gitamol doesn't come back with anything to challenge the unaudited financials other than saying you broke out indirect expenses, but that happened before the agreement was signed. So in closing, I'd say that forecloses both the merits and discovery because there was no 3212F motion, no motion to strike.
You're way over your time, so I'm going to ask you.
I'm sorry.
Yeah, to honor your in closing. Okay, you said
The
it.
same reasons why the merits are ineffective. There was enough introduced, and there's an insufficient record to support a 3212F discovery request that wasn't even the basis of the motion for more discovery below. Thank you, Your Honor.
Thank you. All right, 2 minutes rebuttal. Go
Yes,
ahead,
thank
Mr.
Your Honor,
O'Brien.
very briefly, Mr. Friedman does not, in his affidavit, as Mr. Pollack stated a couple times, explain the calculations or justify these expenses. He does not do it. So I would ask the court when it can and it's examining this, Mr. Friedman does not explain that, nor did Mr. Sivan, the CFO. If he could cite in the record where Mr. Friedman said that, I'm sure he would have done that. They came forward. Mr. Friedman does not even say that RAM complied with the agreement. He does not say the expenses are reasonable. RAM failed to carry its burden on summary judgment. And they don't, I mean, that's the very simple point. And in terms of conclusive, Your Honor, The lower court did not hold that these financials were conclusive. His entire analysis is Mr. Gitamol, the non-movement, didn't carry his burden. We know that's in error. It shifts the burden to Mr. Gitamol, and he held that if you look at some of the records, Mr. Gitamol failed to carry his burden. That is erroneous. Summary judgment should be reversed. And when this case goes to trial, Mr. Gitamol is entitled to prove that these expenses were improperly shifted to deny him all of his profits. Thank you very much, Your Honor.
Thank you. Thank you both. The next case for argument is Wilson versus Wilson. Good. We have Mr. Goldstein.
Yes, Your Honor. May I begin?
You may.
Okay. Well, we're appealing the denial of a motion for a new trial that was made by Mr. Wilson. It is, and it has been undisputed, that Mr. Wilson had a long history of severe neurological problems, psychological problems. He had a stroke. He suffered from epilepsy, seizures, a brain tumor, and had actually had a brain operation to remove his tumor just 9 months before this trial. The operation was not successful because his seizures continued, so much so that he had to have an emergency MRI, which was scheduled for 2 days after the trial was scheduled to begin. Mr. Wilson asked the court for an adjournment, forwarded the court a doctor's letter, and the letter said,
It wasn't a doc. Let me stop you for a minute. It wasn't a doctor's letter, and in fact, the court made a point of it because the court was concerned. The court had given your client an opportunity to get documentation or an affidavit from a doctor to confirm to him, or to, when I say him, the trial court, that your client was unable to proceed to trial in light of the medical situation. And what the court was presented with was a letter, right, from somebody at a medical facility.
Yes, that was it was his primary care facility.
Well, it had just become. They had just started treating him.
No, he had moved to North Carolina and switched, went to, a new primary care facility.
Right, so we agree. They had just started treating him right before the trial.
Well, no, it wasn't right before the trial, Judge. It was well before the trial that he started.
What do you consider well before the trial?
I don't have the date in front of me, Judge. I just don't. I'm sorry. I can look it up in the.
No, unnecessary. I'll look it up.
But so, it was not his understanding that he needed an affidavit to begin with, and then nowhere in the transcript did the judge say that he asked for an affidavit. So I'm not so sure. And besides, he was representing himself, and he's not a lawyer at this point. It's the whole thing is extremely unfortunate.
I'm sorry, counsel. This was a letter was this the one from Doctors Lander and Kennedy? Kennedy said that he had been his patient since August 2017, and then he traveled. Is that correct?
No, that was not what was submitted to the court. That was submitted in connection with Mr. Wilson's motion to vacate the judgment to confirm that this was a serious issue. What was submitted to the court was a different letter or note from his primary care physician after consulting with Dr. Kennedy, his neurologist.
It was from a facility. It was from a nurse practitioner or something who submitted that letter.
Physician's assistant signed the letter, yes, on behalf of his primary care consultant people. So that was what was given to the court. Well, his primary care facility.
That we're really drilling down on this is because the trial court, who knew about your client's medical condition and had seen his functionality during this period of time, although he didn't doubt your client's medical condition, did not understand it to be as dire as requiring the delay of a trial. So that's why these questions from us are to see, was this really as your client portrayed it, or was the court within its discretion making an appropriate observation that this trial should have gone on?
I understand completely. And the two things I would say about that is, number one, the court itself mentioned that they were considering, talking about having a guardian appointed for Mr. Wilson. And the second thing is, I try to, put yourself in Mr. Wilson's position for a minute, and you do get a recommendation from your physician saying that to avoid stress and travel at this time. And this, and this was the recurrence of his seizures, which the brain operation 9 months earlier was supposed to have fixed, but it didn't fix. So now Mr. Wilson's in a position, having received this advice, the advice is turned over to the court, and he made a decision and the decision was that he'd rather not risk losing his life over that. And the question on the 1515A is simply, is that a reasonable excuse?
I don't know that there was anything that indicated he would be risking his life, but we understand your argument.
Right.
Let's hear from the other side, because you're way over your time. I'm sorry, it's a busy calendar today. Everybody's getting the same consideration, the time you got. So let's hear from the other side.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Sharon T. Hoskins LLP, for plaintiff respondent Mary Pierce Wilson. We ask that this appeal be dismissed and the lower court decision affirmed. Appellant is seeking a new trial on the basis of law and claims that were not even presented to the trial court for consideration in the underlying motion. His brief asserts CPLR 5015A1 as the basis for vacatur, while his motion papers relied on CPLR 5019A.
Just remind me, was he pro se when he made the motion to vacate the trial decision?
No, he was not. He was represented at that
time. So,
and
they chose a different CPLR section of 5019, saying that there were errors in the judgment,
correct.
Right? I mean,
correct.
that wasn't excuse my default for not showing up.
Correct. And so in the underlying motion, it was completely relying on that other section, CPLR 5019. But in the motion, in the brief for the appeal, the argument is based on 5015A, and it is not.
Yeah, but doesn't the fact that the judgment is being appealed bring up for review the denial of the adjournment? I mean, because that's really what we're talking about mostly.
It brings it up, but it is not permissible to bring up new theories and arguments on appeal that the court did not have a chance to consider, and the other party have a chance to argue on in the lower court decision. And if we're talking about specifically the denial of the adjournment and right. The excuse for being absent, we have to remember that you stated earlier, this court had been with these parties for years and was very well versed in the history, the circumstances, and what had happened heretofore. Now, when my opposing counsel talks about the timing of this letter from the physician's assistant, it did not occur until after the appellant had asked for an adjournment from the court. It was denied and said, if you have a medical issue, then you need to get an affidavit from your treating physician. He didn't do that. He didn't have a current treating physician in North Carolina for the 9 months that he was there since his operation. His treating physician for the operation was in New York, and that was November of 2016. He then moved to North Carolina, and during that time sought no treatment, or at least did not offer any evidence that he had sought treatment at all until he needed an excuse to not appear for trial. Not only that, there have been numerous appearances before the court where there was never anything brought up by the appellant to say, I'm having some serious difficulties, I can't move forward. In fact, he made the decision to fire his counsel, and even the court gave him additional time to maybe reconsider that very dire decision, and came back on a second appearance He fired him. He affirmed his desire to fire his counsel, and the court did relieve his counsel, who had at that time finally asked to be relieved of representation. So there is plenty of evidence here to show that his refusal to attend the trial was willful, and that's one of the other factors to be looked at when considering excusable default. His absence was willful, and the other factor is the prejudice to the other party. My client filed for divorce in 2014. This trial was scheduled now 3 years later in 2017, having previously been scheduled for trial before. And I might add, the earlier trial was scheduled for November of 2016, and that is when the appellant asked for an adjournment of that trial because he had the surgery. That's understandable. I'm not taking issue with that.
Right. I'm going to ask you to wrap this up because your time is up.
Okay, just one more point. It's just I wanted to state also that in terms of the original claims of error and inconsistency in the judgment, they fail as any proof of a meritorious claim or defense. And they were actually not even offered as a proof of a meritorious defense in the underlying motion.
Okay, thank you. We'll read your brief. Right. Mr. Goldstein?
Yes.
Go ahead. I'm sorry.
Very briefly. First of all, what was just said, there is just no backup in the record for any of this stuff. So you can search the record for everything she said. There is no backup for any of that stuff, and it's not right. The second point is that one of the grounds
I'm sorry, Counselor. Excuse me, Counselor. What is your legal definition for all of that stuff? What are you referring to?
The timeline of Mr. Wilson seeing doctors and all of that stuff, and you know, is willful, trying to get out of the trial willfully. Even the judge mentioned all of his neurological problems, so it's not that simple. But I just wanted to point out,
Counsel, had Mr. Wilson made several appearances prior to it being scheduled for trial? And he was
yes,
able to
and he had been in many appearances before the court before the trial was scheduled. He didn't ask for any. This is the first time he ever asked for a trial adjournment. The other adjournments were because the judges. This is the fourth judge on the case. Other judges were not able to go ahead on the dates they had originally subscribed to go ahead on. I wanted to point out that, you know, the main argument that was made is that there was no request in the 5015A for the vacating the judgment, but there was a request. It's the last item in the notice of motion to vacate the judgment, asks for vacating the judgment on the ground of excusable neglect, which is close enough. You do not need to cite a statute in order to have a ground for a motion.
Okay. All right, we understand your argument, Mr. Goldstein. Thank you.
There are millions of dollars that they took advantage of. Yeah.
Thank you. I'm sorry. We have your briefs. Honestly, we're pretty familiar with your case. Thank you.
Have a good day.
Okay. You too. All right, the next case is People versus Acosta.
Excuse me. Good afternoon, and may it please the court. Chloe Surinsky on behalf of Appellant Adonis Costa. I'd like to start with the first point, which is that appellant's plea was jurisdictionally defective, where it was a plea to the same and a higher level offense than the charges in the indictment. It wasn't a constitutional lesser included offense, and it wasn't statutorily authorized by CPL 22020. Now, I'd like to begin by directing the court's attention to the umbrella provision at CPL 22020 subdivision 1, which starts out by clearly stating that lesser included offense refers to a plea to an offense of a lesser grade than one charged in the indictment. And that clearly applies to all the following subdivisions, including subdivision I, which is the one that is at issue in this case. This is also completely in line with the legislative history of the statute, which the prosecution doesn't refute and which is abundantly clear that.
Counsel, let me just ask you, this plea, wasn't this the result of extensive negotiations between the defendant and the prosecutor's office? And the end of it is that this plea was probably thought up to avoid immigration consequences. Isn't that the end of it?
I think the record does show that there was negotiations. Unfortunately, and this goes to the second point, the Lopez issue. Counsel didn't successfully negotiate a plea that was any better for immigration than the charges in the indictment. But it doesn't really go to the jurisdictional issue, which is that the plea still has to be sufficient for jurisdictional purposes. Here, it wasn't constitutionally, it wasn't under the statute. I'm saying there's a very clear provision at the beginning of CPL 2020, which says that a lesser included means a plea to a lesser grade. Then the legislative history is very, very clear that it's referring to only, for purposes of subdivision I, it's referring only to criminal possession charges in a lesser degree than the one charged. And that this has actually always been the case. The former criminal procedural code, allowed pleas only to offenses of lesser degrees than the crime charged. And then the legislative documents and history is very clear that Article 220, when it was enacted, was intended to substantially limit the kinds of still lesser offenses, but the kinds of lesser offenses which could be properly pleaded to, not expand them. And this was reaffirmed by the Court of Appeals in People v. Johnson and Kaiser, where it said that Article 220 imposed stricter criteria on the plea bargains, but still for lesser offenses, like its predecessor statute. And that the point of these restrictions was to prevent prosecutorial excess. So this is not only clear in the statutory language and the legislative history, but also in case law.
Is this a situation of prosecutorial excess? Because it seems to me that the reason that we're here is because there was an attempt to come up with a resolution that would not have an immigration impact, and you all failed.
I'm not sure if it was an example of prosecutorial excess, but it still doesn't. It's still not jurisdictionally appropriate. There's just nothing that authorizes it.
That may be true, counsel, but I suspect that everyone knew that when going into it. Right? I suspect that the very purpose of going for this plea is, again, to avoid the immigration consequences. And now that that didn't happen, now we fall back on, well, this is all illegal to begin with.
I think it's a separate issue, and we addressed it in our second point with Lopez. So counsel, to that point, is there an argument to be made that a jurisdictionally defective plea survives a waiver of a right to appeal as well as survives a guilty plea? Yeah, there's just case law plainly stating that, and I cite it in my main brief. But yeah, jurisdictionally defective plea survives a waiver of the right to appeal and also a guilty plea. And I'm trying to find the case right there, but it's People v. Martinez, which is a case that this court decided in 2001. People v. Seals. There's numerous Court of Appeals cases as well. I don't want to conflate the jurisdictional issue with the Lopez issue. I will be happy to address the Lopez issue, but it's a separate one. The plea still has to be jurisdictionally appropriate, simply as a separate issue. And this is, this is also identical to the situation in Martinez, where this court found, in almost identical circumstances. The defendant was charged with 220-061. It's the criminal possession with intent to sell charge.
We're familiar with that case, and let's hear from your adversary.
Good afternoon.
People, we have time constraints. That's my mantra for today. So, but we're familiar with the Martinez case.
Good afternoon, Your Honors. May it please the court. My name is Sheila Bautista. I represent the respondent in this case. Can you hear me?
We can.
Thank you. Your Honors, this court's prior decision in Gill is exactly on point here. Gill was a case that decided—
Can I ask you a question, though? And I know it's not apparent from Gill or Martinez on the face of them. You have to go back and look at the facts of each one. But don't the two cases seem at odds with one another?
The results and the outcomes.
Right, they seem inconsistent, right?
The difference is that Gill has to do with 220.21I and Martinez has to do with an SCI, which is governed by CPL 195. Now, in my adversary's reply brief, they talk about how the restrictions of CPL 220 apply to SCIs. However, the 220.21, which allows pleas in any degree, and that's the plain language of 220.21 subsection I, is allowing pleas in any degree.
Isn't it subject to the precatory language of the entire statute?
Well, according to the reply brief, 220.10 refers to the exceptions applying to SCIs. We are dealing with 220.21 subsection I. There's no language that says that 220.20 applies to SCIs.
But isn't it the structure of the statute itself? It starts before you get to any of the subdivisions. Doesn't it make reference to pleas of excluding pleas that are of the same grade?
Right, but 221I specifically says pleas for possession when a person has been charged with possession in any degree. That plain language.
I understand that, but I don't think that answers my question. Is that an exception to the beginning language? I'm just trying to understand statutory construction. How do you construe it? What do you think that precatory language means in the context of subdivision I?
It's an exception to the restriction of 220.20 of what comes before it. 220.21I is an exception to the restriction.
It's not an additional. It's an exception and not an inclusion. That's how you read it.
Right, it's an exception to the restrictions of 220.20 of what comes before, and that's what this court held in Gill. This court held in Gill where a defendant was charged with a Class C felony could plead to a Class C felony. In People v. Johnson, that supports this decision's in Gill. People v. Johnson was a case where a defendant pleaded to a Class C sale, which wasn't allowed because it wasn't the same level possession charge that he had been charged with. And in Johnson, the Court of Appeal said—
But, counsel, why are we drawing a distinction between a plea under an SCI and a plea to an indictment?
Because Martinez and Seals were cases where a defendant plead to a same level was under an SCI, and the courts in those cases found that those pleas were jurisdictionally defective.
No, I understand that, but I don't understand. Why is there a distinction between a plea to an SCI and a plea to the indictment?
A grand jury indictment, the way it's brought is different than an SCI. A grand jury indictment is brought when a grand jury hears evidence and decides to bring. Right.
Trust me, I understand what an indictment is as opposed to an SCI. I kind of have some familiarity with that. But what I'm trying to figure out is why would there be a distinction? There's the same consequence when you plead to an SCI as where you plead to an indictment. Is the argument that you're pleading to the SCI is more for dispositional purposes as opposed to an indictment? I just don't see how you draw a distinction between the two.
Well, the legislature didn't provide for the same exception to the restriction to the SCI. I don't know why the legislature doesn't explicitly provide for it the way it does under 220.21I, but perhaps, the SCIs, usually they're brought with an eye towards a plea, whereas an indictment isn't always brought with an eye towards a plea. So perhaps that's why the 220.20 allows for the pleas where where sometimes non-citizen defendants can benefit. They can benefit with the better immigration consequences. It's not in the record whether or not this defendant is a green card holder or not and would benefit. However, this plea to the possession weight versus possession with intent to sell is a plea that other defendants in other cases have requested because of the immigration consequences. So if this court were to
let's just stop you. I mean, we're all recognizing that there may be immigration reasons why they did that, but that doesn't make it jurisdictionally right. So well, in any event, your time is over, and we're going to hear rebuttal from your adversary.
Thank you, Your Honor.
Go ahead. Thank you.
I want to make a few quick points. First of all, the Court of Appeals in Domico has found that the plea bargaining restrictions under 22020 apply equally to SCIs. CPL is clear that the restrictions also apply to SCIs, and that's in the practice commentaries of CPL 195/20 also. And to Your Honor's point about statutory construction, obviously the prefatory clause does go on to limit what's underneath it and to the extent that there's any confusion about statutory construction, that's when we go to the legislative history, which is clearer than clear that we are only talking about pleas to lesser degree offenses. Now, I also, Your Honor, was looking at Gill and Martinez kind of side by side and wondering how to read them together. And I think one thing that became clear to me is that Gill was a case where the indictment, along with a number of other offenses, charged the defendant with 22016, and then the defendant pled guilty to a lesser degree offense, which is the attempted 22016. And you know, the judge had later gone on to dismiss that charge, but CPL 22020 specifically talks about indictments. And then in Gill, the court actually cites Johnson and Kaiser and says, you know, there's no jurisdictional defect because his right to be prosecuted by indictment wasn't impeded. Now, Johnson and Kaiser both say that there's a jurisdictional defect implicated when there is a plea to an equal or higher degree crime than the charges. And lastly, I just want to point out that policy-wise, the prosecution's desired interpretation would lead to disastrous results. It would mean that a defendant who was charged with, you know, one count of misdemeanor possession could properly plead to, you know, an A1 felony possession charge, which is exactly the type of prosecutorial excess that
even if that didn't occur in this particular case, this is the policy behind how to read it. It's your argument, correct?
That's correct. That it's very
okay. Clear. All right, we understand the argument. We understand. All right. Thank you both. It's
Your Honor.
An important case. Ricardi versus State of New York.
Good afternoon, Your Honors. Brian Isaac, I represent the appellant. Judge Gish, in accordance with your directive, I'm going to try to be brief and stay under my time, so let me get right to it. If Article 2 of the CPLR doesn't apply to my 8B claim, I'm dead. I lose. Why do I say that the claim should apply? And here's the reason. If you look at Section 9 of the Court of Claims Act, subparagraph 9, the general rule is that rules in the Supreme Court apply unless there is a specific reason not to apply, such as a difference in the statute or a difference in the rules. We know from the Court of Claims Act subdivision 10 cases that the courts there, and I'm specifically speaking about Pelnick, Kaplan, Fleming, and Gurley, took the position that because there were multiple subdivisions of the statute, and because some of those subdivisions mentioned Article 2 and others did not mention Article 2, that in order for a plaintiff to fall within the ambit of the statute and use any of the provisions in CPLR Article 2, you had to fall within that specific statute, or that specific subdivision. With respect to Section 8B, there is no reference to CPLR Article 2 at all. It's just silent on it. And I think there's a fundamental difference between having a construction, because we're talking about statutory construction, where you rule something out where something is mentioned in a statute and where something's not mentioned at all. My position is that from the statute itself, from 8B itself, and I'm referring to 8B subdivision 1, there should be a construction of that statute which favors rather than disfavors an application of this type. And it's kind of remarkable because, as you just heard in your arguments, you're talking about legislative history. Here, the legislative history, as far as I can tell, is right in the statute proper itself. First sentence of the statute, I'm quoting, not Brian Isaac, this is the legislature. The legislature finds and declares that innocent persons who have been wrongfully convicted of crimes and subsequently imprisoned have been frustrated in seeking legal redress due to a variety of substantive and technical obstacles in the law, and that such persons should have an available avenue of redress over and above the existing tort remedies to seek compensation for the damages. Second sentence, the legislature intends by enactment of the provisions of this section that those innocent persons who can demonstrate by clear and convincing evidence that they were unjustly convicted and imprisoned be able to recover damages against the state. Not going to read the third sentence, but it essentially talks about the difficulty of proof and the fact that courts should actually give claimants in this type of situation a lesser burden of proof. That's simply not fostered in a situation where the claimant, like the one here, died when the claimant did nothing wrong. If you take a look at all of the other cases cited in my adversary's
right. No, we understand that there was a period of time after a claimant died. They were within the statute of limitations. They apply for letters, and the letters are not issued until the statute runs. I mean, that's what happened here. But how do you address your adversary's argument that because these kinds of claims involve a waiver of sovereign immunity, that you would need an express provision indicating that the provisions of Article 2 of the CPLR, which really told the statute of limitations, apply to give this claim viability?
So my argument, Justice Gish, is this. I lost Lichtenstein against the state in the Court of Appeals. So I know what the restrictive jurisdiction is, and I know that it can be a very, very difficult construction. My point is that the cases that are relied on don't involve 8B and don't involve not a disability tolls, but the death tolls of Article 2 of the CPLR. And the reason why you don't need it is because this statute is different. It is a standalone statute. The statute is designed to afford claimants the right to have a cause of action where they're unjustly convicted. Here, my client spent 3 years and 7 months in jail, and the claim is that he was convicted of a crime that he didn't commit based upon a fraudulent claim of people who were involved in the act. And I would point out to you that just policy is still important. And this court, probably of all the appellate divisions, has been at the forefront of examining new kinds of issues. It recently held that you couldn't have spoliation with respect to a body part. All the lower courts said you could. It recently changed its prior decision regarding notices of claim as to whether or not you need to name the individual defendants. And since the crane collapse case, if you look at the jurisprudence of this court with respect to damages, it has materially increased those damages, dealing with the trilogy of cases involving brain damage and the recent Yvonne Y decision. The decision has to make sense. Statutory construction shouldn't be used to disaffirm what the legislature intended. And I would just say one other thing, and I'll stop talking. I did posit a hypothetical in my brief. Plaintiff is ready to file a claim. Just under 2 years, he dies. Under that scenario, that claimant, even though he would have a claim based on the state's paradigm, would never have a claim. I don't think that's fair. I don't think it's consonant with the statute. I don't think it's required by the cases. Thanks for listening to me.
Thank you. All right. Let's hear from the respondent.
May it please the court. My name is Stephen Yanni, and I represent the state. The court should affirm because the claim is untimely. Section 8B waives the state's sovereign immunity only where the claim is brought within 2 years. And here the 2-year period expired in February 2020, and the claim was not filed until June 2020. The CPLR's tolls do not apply to modify Section 8B's jurisdictional 2-year limit. The CPLR applies in the Court of Claims only to the extent provided by the legislature. And the legislature chose not to incorporate the CPLR into section.
So in other words, the absence of any reference to Article 2 of the CPLR in 8B, you think cuts the other way from what Mr. Isaacs is arguing, that's what controls it. There's nothing in there.
That is our position, Your Honor, and that's because Section 8B7 specifically provides a 2-year limitations period without any exception, and courts have held, including this court in Taylor versus State, that we have to construe Section 8B7 strictly, and on that very basis, this court held that CPLR 205A did not apply to modify Section 8B7's 2-year requirement. So this court has already confronted the same concerns that my friend raises and has decided that notwithstanding them, the claim can't survive in those circumstances. And
so is Mr. Isaacs correct in his hypothetical? And in that hypothetical that he just gave, there would be the claim would be barred?
That's correct. The claim would be barred, Your Honor. And the courts have uniformly recognized that Section 8B's filing requirements are jurisdictional conditions precedent to bringing suit, and that they have to be strictly construed, even if that results in the claim being lost. In particular, in reaching this conclusion, the courts have focused on the text and structure of Section 8B. Now, I know my friend focused on some of the provisions in Section 1, but the very structure and other provisions of Section 8B show that this is a strict statute with strict requirements. It doesn't incorporate the CPLR's tolls and exceptions. It doesn't allow for the filing of a notice of intention to file a claim or allow for late claim relief, and it places a high burden on claimants to prevail. And I would also note that if it were the case that Section 9.9 incorporated the CPLR's tolls, as my friend argues, then there would have been no reason for the legislature to specifically incorporate the CPLR's tolls and exceptions in Section 10.6. So, and I think the court should not read into Section 8B what the legislature intentionally left out. And that brings me to my second point, that late claim relief is not available here because Section 10.6 specifies that it only applies where the claimant hasn't complied with one of the foregoing subdivisions of Section 10. But it is Section 8B7 and not any provision of Section 10 that provides the applicable limitations period here. And for that same reason, the Court of Appeals in the Yonkers case held that where the statute of limitations is found outside of Section 10, late claim relief doesn't apply. So for all of these reasons, and unless Your Honors have further questions, I would ask the court to affirm. Thank you.
Any rebuttal?
Yes, Your Honor. I never claimed that the 2-year statute of limitations was anything other than a 2-year statute of limitations. It's in the brief and it's in the reply brief. The question is, can that be told? The Taylor against State case that my friend spoke about has nothing to do with a disability toll based on death. What happened in that case was this court held that where a claim was dismissed because it was not properly verified, 205A didn't allow it to be resuscitated, and that's predicated distinctly on Long against the state, which held that exactly. The fact is that this is a very unusual case that doesn't fall within the ambit of the other cases. And if we're going to use statutory construction arguments, my point would be that it's well settled that a statute should never be construed, even where it's literally proper to do so in a manner that is antithetical to its interests. Given my friend's assertion and admission that in my hypothetical, a claimant who should have a claim would not have a claim, we submit that this court should reverse the trial court and not dismiss plaintiff's case. I have nothing else unless you have any questions for me.
Any questions, colleagues?
Thank you.
Thank you. Thank you both. The next case is Feuerman versus Marriott.
Good afternoon, Your Honors. May it please the court, Andrew Fisher on behalf of plaintiffs' appellants. It is our contention that the motion court erred in granting defendants' motion to renew, where defendants failed to offer a reasonable justification for their failure to submit an expert report in support of the underlying motion for summary judgment. Indeed, on renewal, defendants submitted the same recycled facts they submitted in support of the motion for summary judgment via their unsworn expert letter report, now transplanted onto a newly drafted affidavit.
Well, that was the whole point, was it not, counsel? Did they not state that it was inadvertent on their part that they meant to submit the sworn to affidavit, and they inadvertently submitted an unsworn to affidavit?
They claimed that, Your Honor, but without any support. And it wasn't an unsworn affidavit. It was a letter report that differed significantly in form from the affidavit that they later submitted.
Well, can we talk about the differing in form? Isn't that exactly the point of the trial judge? It only differed in form. Once it was sworn to, it conformed to the form required of an expert report, and she went on to look at the merits. What's wrong with that?
Because, Your Honors, this was not an inadvertent error in submitting the unsworn report. Defendants intended to submit the report in unsworn form and failed to realize that an affidavit was needed. Indeed, on page 324 of the record, in their reply papers on the motion to renew, defendants admitted, quote, that they neglected to appreciate the need to attach a duly sworn affidavit.
Well, so they made a mistake. I read that as, gee, we really made a mistake. You could maybe even say it more forcefully, but that's it. That's the end of it. We don't get to the merits because of that. When somebody falls on their sword and said, I made a mistake. I thought I could do it this way. I needed to do it in a different form. Now here it is in a different form. You really think that is just out of the bounds of what the trial court should be able to consider?
On a motion to, and we have a motion on a motion to renew. Why? I'm not understanding why would that be insufficient on a motion to renew? We're renewing because we made a mistake. I mean, it was inadvertent. Why would that be beyond the pale of within the discretion of the trial court, of the motion court to consider it?
But again, Your Honors, this wasn't an inadvertent mistake. In situations where this court has held that an omission was inadvertent, it's a situation such as in this court's decision in Cespedes versus McNamee at 308 82nd 409, where
well, so let me stop you. What possibly could be the deliberate reason for an attorney to put in an expert statement report in the wrong form? What would be the motivation? So that the motion could get denied because it's in the wrong form? I mean, what would be the motivation for not having the report in a sworn to statement? I just, you keep saying it's deliberate. Deliberate for what?
Not
what? To do what? To accomplish what?
Not deliberate, Your Honor. Not deliberate in intending to submit it unsworn, but deliberate in the sense that they thought that an affidavit was not required.
Was sufficient. And that was wrong.
That's a mistake.
That's a mistake.
And that's a mistake. And they attempted to rectify that mistake by moving to renew and submitting an affidavit in proper form.
But as this court held in both Gibbs and in Carey, on which Justice Weber was on the panel, the movements in those cases provided similar excuses in saying that they thought it was unnecessary to include an affidavit.
Gibbs dealt with issue as to due diligence. Gibbs was different. That was a failure on the party to submit an affidavit in due diligently. That was the issue. That's not what the issue is here. And again, this affidavit, the motion court specifically stated that they had made out a prima facie case. The only problem was that the affidavit was not properly sworn to. So again, I don't understand what the basis would be to deny the motion court their discretion in granting the motion to renew.
Well, just briefly, Your Honors, because I don't want to go too far over my time.
You're already over your time, so just you can answer the question. Go ahead.
It's critical that the law and the basis for 2221 is not to give them a second chance, not to give movements a second chance to correct an error that they shouldn't have made on the original motion. Here, they submitted an unsworn letter report because they didn't do their due diligence in realizing that an affidavit was necessary. And now we're attempting to correct that by submitting a new affidavit that was signed 7 months after the original motion and 2.5 years after the unsworn letter report. For those reasons, this court should reverse.
Thank you. All right. Respondent?
Good afternoon, Your Honors. May it please the court. My name is Jose Gomez. I represent the defendants, respondents in this case. And this court.
Mr. Gomez, I want to be perfectly clear. When your client put in the renewal, there were no changed facts, right? The simple change here was that what had been in the form of a report was now in the form of a sworn to statement, right?
Correct, Your Honor. That's an important.
You didn't bring up new facts.
Correct, Your Honor. Plaintiff's counsel does state that the resubmission is different, but if we look at the record, and the original submission is on page 145, the resubmission is on page 292, it is the same identical report from the expert along with his CV being submitted, but on renewal, there's an extra page, a single page affidavit with 7 lines that basically just states, this is my report, and I swear under oath that it is truthful. That's the only change. The report itself stays the same. And that's important because renewal is not meant to allow bringing in new evidence that you should have submitted on the initial try. It does allow, 2221 does allow this court and the lower courts to correct procedural defects like this one, where an unaffirmed report is submitted affirmed or submitted improper admissible form. But if I were to submit a different report or a report from a different expert, that would be a different question.
Counsel, when the motion for renewal was finally considered by the court, did the motion court consider the plaintiff's opposition at all?
The initial motion, Your Honor, if my understanding is correct, was not necessarily orally argued, but I do want to point out something important, which is after, I'll refer to myself in the first person because I was the one who drafted the underlying motion. After I submitted the motion with the expert's report in inadmissible form, the plaintiffs did exactly the same thing in opposition. They submitted their own expert's report in the same format. It was a letter report, a narrative without any sworn statement. And so that was never argued on the papers, at least. It was the court on its own that found that error and used that to deny the motion, but without prejudice. That error was corrected on renewal. That was the only change made. There was an additional page submitted, a cover page to the report, which was an affidavit from the expert attached to the same exact report. And that court considered that to cure the initial defect, went into the merits and granted the motion. And that court had the discretion to do so. The question here is, did that court abuse its discretion when it allowed me to correct that defect? And it didn't, because this court has upheld many similar cases where somebody submits an affirmation from a chiropractor, which we know the CPLR doesn't allow. They correct it and they submit a proper affidavit, or they submit an affirmation, but it's not signed. So they submit it and it's signed. And this court and the Second Department have routinely upheld that exercise in discretion. In fact, the plaintiffs have not cited, and they have the burden to do so, they have not cited a single case where this court or any appellate court has found that the lower court abused its discretion in allowing a procedural defect like this one to be corrected. In the cases where lower courts have found that the motion to renew was improper, they were different. There were cases where, as Justice Weber pointed out, in one case, the plaintiff didn't submit any affidavit, and on renewal submitted an affidavit. That's not what we're trying to do. There was another case where the movement submitted an affidavit from person A, and on renewal submitted an affidavit from person B. That's not allowed. We are just correcting one single procedural defect, and that is whether that motion was supported by a properly affirmed or notarized expert report. And on renewal, it was, and there was no abuse of discretion in considering that.
Okay, thank you. Let's see a rebuttal from your adversary. Mr. Fisher, go ahead.
Thank you, Your Honors. Just briefly, the key point here is the lack of reasonable justification. They're claiming that this was inadvertent, but their evidentiary submissions show otherwise. Yes, they attempted to correct the failure to submit a sworn report with an affidavit, but it was a new affidavit clearly drafted after the original motion, and their excuse is claimed to be inadvertence, but they admitted that they failed to appreciate the need to submit an affidavit. And as this court decided in Carey, where the movement stated that they thought it was unnecessary to include an affidavit, the court there found that the movement didn't provide a reasonable justification and denied the motion to renew, as this court should do here. Thank you.
Okay, thank you. Thank you both. The next case for argument is Carmel versus Young Men, Young Women's Association.
Good afternoon. May it please the court. Elizabeth Islander on behalf of Appellant. Your Honors, because of the irregular steps, the plaintiff stumbled. And because there was no available handrail for her, she had nothing to grab onto and she fell to the bottom of the stairs and fractured her hip. This court needs to look no further than its recent holdings in the Gill versus Margus case, which is a different Gill case than in the criminal matter before us.
Yeah, I was gonna say.
Yeah.
So this is 183 AD 3rd, and that was in May of 2020, that the court below had available to him when he decided our motion. So I'm surprised that it's not mentioned anywhere in the motions.
So, counsel, you stated that there was no available handrail. I looked at the video, which was very clear, actually, one of the better videos that I've seen. And there were handrails on both sides. There was a handrail on the left side. There was a handrail on the right side. She kind of went up the middle, veering off to the right.
So, yes, Your Honor, but the issue of whether or not the plaintiff could have or should have used the side handrails, as this court, in fact, Your Honor, Judge Weber, you were on that panel in the Al Abdi case issued in April of last year. Whether or not the plaintiff used the side handrails that could have been available to her is really an issue for comparative negligence, and that's not an issue on summary judgment. The court below completely ignored Al Abdi and Gill, as did the defendant respondent. The issue here is whether or not the plaintiff had an available handrail in the middle of the staircase. And under the 1922 building code, the steps were in excess of 88 inches and accordingly should have had a middle handrail. The plaintiff's deposition and the video, which I agree with Your Honor, I think it's clear also, the video is completely consistent with the plaintiff's testimony. And in fact, the plaintiff testified quite clearly, and in the record on page 125, she says, when I was looking around for something to grab onto, when I was unbalanced, there was nothing to grab. It was too far away, indicating the side hand railing. And on page 119 of the record, the plaintiff testified, I tried to right myself. There was no rail to go hold on to. That's exactly what the plaintiff said in Al Abdi. And what the defendants argued was that she could have had reached for the side handrail. And in Al Abdi, this court found that whether or not the absence of a handrail was a proximate cause of the plaintiff's fall is an issue of fact, and it should go to the jury. The lower court in this case really engaged in, for lack of a better word, a mini bench trial, and basically said, I looked at the video. I don't think it was speculative to say she would have used a middle handrail, but frankly, the lower court misquoted the plaintiff's deposition. The court noted on page 19 of the record that the plaintiff, quote, never testified with respect to reaching out for a handrail. And that's just not true. That's plainly inaccurate. She says on page 19 of the record, there was no rail to hold on to. So she was flailing away, which can be seen for the video. I'm glad that Your Honor watched the video. So she had nothing to hold on to. And that's really the whole point of a handrail, because you have to assume, and everybody assumes, that when you're going upstairs, sometimes people lose their balance for various reasons. In this case, it had to do with the irregular riser heights. And even the defendant's expert agreed with my expert that the riser heights deviated. The first step was 6.5 inches, then 7, then 7.1. And so the irregularity of the steps and the fact that they were 15 inches deep created an erratic step pattern for the plaintiff. So that put her off balance. And as the defendant liked to say in their papers, she misstepped. I agree with them. She misstepped. But after all, that's why we have handrails, and that's why the building code requires that you have a handrail, because if someone is losing their balance, then they have, as my grandmother would say, what to hold on to. And we didn't have that here. There's no dispute there was no center handrail. The court below found that the 1922 building code applies. At best, it's potentially a battle of the experts at trial, but certainly not appropriate for a summary judgment finding.
Thank you. Yeah, you'll have time on rebuttal. Let's hear from your adversary.
Happy New Year and good afternoon. May it please the court. The lower court correctly held that the proximate cause of the plaintiff's fall in this case was her own misstep. Specifically,
I ask a question though. I mean, and this was somewhat confusing to me. We do have kind of robust case law at the appellate division that the absence of a handrail can be a cause of a fall. A jury could find that the inability to grab something to break your fall may be a cause, correct?
Yeah, absolutely. However,
so the question really is there was a lot going on, and it was a very clear video, and there may have been a lot of comparative negligence here. But does that mean that as a matter of law, we rule out the fact that the absence of a handrail may have played some part in this accident?
I think the most important and significant part of that question is what both Judge Weber as well as yourself have mentioned. This is an incredibly clear video in that the handrail played no role in this plaintiff's accident. What distinguishes
how could you say that it wasn't there? You can't say that something that's not there played no role. She did. You can't see in the video when she started to fall, she reached out. She couldn't hang on to anything. There was nothing within her grasp from where she was situated on the step. So I don't know how you could draw that conclusion from the video, quite frankly.
The plaintiff herself testified, record page 145, that what she reached for was the door. She specifically,
of course, she couldn't reach for what wasn't there.
No, meaning that pursuant to her own testimony, she climbed up the first step, she climbed up the second step. There were no problems, there was no uneven steps. Moreover, she testified that the only irregularity she noticed was an irregularity that she saw after she fell when she sat on the steps. What the plaintiff is now asking you to do is to speculate that no, she would have grabbed onto a middle rail. But in fact, what she testified to incredibly clearly was when her right foot went onto the third step, the right foot never actually stepped on the step. In fact, actually, the seam hit the top.
Doesn't that just go to comparative negligence? If anything, she can't reach for what's not there, right? I mean, that's just common sense. But she did reach out for something to break her fall, and she did testify, I reached for the door because visually that was sort of on the top step, the closest that she saw in the moments that she was falling. So again, I don't really understand the argument. It didn't play. How could it not? How could you expect her to reach for something that's not there? That's my question, I guess.
Because the question is, what caused her to be unbalanced? What caused her to fall? This case is distinguishable from Gill as well as Alabadi. What caused her here to become unbalanced, both seen on the very clear video as well as her own testimony, was her failure to actually step on the step.
But counsel, is that really the question? Isn't it, doesn't that go to comparative negligence?
Absolutely.
Is it really the question is that what caused her to fall, as opposed to once she's falling, there's nothing that is preventing her from falling?
Right, but that exact argument, would that side rail have prevented her from actually falling, is speculative in its nature. That's the
counsel, that's the point, because she says that she reached out. So she's reaching out for something. And to Justice Gish's point, she's reaching out for something. There's no middle rail. So if she's reaching out for something, if that middle rail had been there, she could have reached out to that.
But she testified she reached out for the door by arguing that she should have reached out
because the door is there.
No,
but
because
if the middle handrail had been there, perhaps she could have reached out to the middle handrail.
Because pursuant to her own testimony, the door was the closest thing to her. She in fact, I asked her specifically.
Right. Yes, of course. Because the door was present. The door was present, so therefore that's the closest thing to her. If the middle handrail had been present, had been there, perhaps that would have been the closest to her. But the point remains, counsel, that it would seem to me that under our case law, under the line of cases, that this is a question that would go before the jury.
May I just address the prior case law, Gill as well as Alabadi? In Gill, search your record, and your panel decided it. That case involved specifically a plaintiff who testified she did not know what caused her to become unbalanced. She did not know that. Here we know what caused the plaintiff to become unbalanced. We know that.
Yeah, but I think if you look at the whole line of handrail cases, you'll see that part of causation, or one part of causation, could be if a handrail's required and that would break a fall, that can be a cause. It may not be. It may not be the only cause. It may not even be percentage-wise the greatest cause when you get to it, but it is enough to get it to a jury. And the arguments about speculation are for the jury to consider, not the court. That's how I see it.
And also, counsel, I just want to be, you do admit, or you do concede that under the code, a middle handrail would be required.
No, we don't concede that. We don't concede that. Our argument was based on the fact that the lower court was correct in deciding that despite whether or not there is a violation with respect to the 1922 code, the issue here is the proximate cause, and the fact that the only proximate cause of the plaintiff's injury and fall was her own misstep, as opposed to any type of violation. That is what we are saying.
Okay. All right, we understand your argument. Let's hear from your adversary in rebuttal.
Just briefly, as Your Honor said, aptly pointed out, the issue not necessarily is what caused the fall. This isn't we're saying there's water on the step or debris on the step, but once you start to trip, for whatever the cause or by whatever cause, that's why the codes require handrails, so it can stop you from falling, and for the plaintiff in this case, from falling all the way to the bottom and fracturing her hip. So we respectfully request that the court reverse the court below's granting a summary judgment to defendant. Thank you.
Thank you. Thank you both.
Thank you.
The next case for argument is Levovsky versus Levovsky.
Yes. Saul Costi for the appellant. Good afternoon, Your Honors. May it please the court. Your Honors, this is a very difficult case. Unlike the other case we've heard today, this case involves really two children's ability to have their father in their life and the father to be in the children's life. The decision of Judge Dawson below is very much against the weight of the evidence. If you look at the decision, the judge gives the reasons. The judge claims that the reasons are based on the evidence, particularly by Dr. Ravitz, who was the court-appointed child psychiatrist. But if you look at Dr. Ravitz's report, if you look at his testimony, his conclusions actually support the opposite than the findings that Judge Dawson found in her decision.
Well, let me stop you for a minute there. Mr. Kotsky, sure. Let me stop you for a minute. So in these cases, very typically, the court will have a mental health expert do a forensic evaluation, right? It's typical, right? And they often testify at trial, correct?
Correct, Your Honor.
All right, and the weight to be given, the report and any recommendations in there is still for the judge, correct?
I would agree with you that usually there's
it's not entitled to any greater weight than any other bit of evidence that comes in, correct? I think that's the case.
I would agree with that, Your Honor, but
you would
I
agree
agree
with
with
that.
But I agree with that. My point is that
so there's nothing inherently wrong with the trial court accepting some of what the forensics said and rejecting others based upon her own evaluation of the evidence, correct?
Well, not if she's saying she's basing it on Dr. Ravitz's report.
Well, she doesn't have to take it wholesale, does she? Does she have to take it wholesale?
Look at the totality of the evidence. No, of course not, Your Honor. But if you look at the totality.
Okay, so where did she go wrong? Where did she go wrong?
Okay, the first one and the big one, Your Honor, is that Judge Dawson made the decision, which is incredulous, that the mother is more likely to support a relationship between the father and the children based on the evidence presented, in particular Dr. Ravitz's testimony. Dr. Ravitz actually had a concern that, first of all, the mother was sharing too much information with the children. The children told him repeatedly when they were interviewed that mommy thinks daddy's a bad guy, daddy stole mommy's money. In addition to Dr. Ravitz, also the AFC, the attorney for the children, indicated that she was also concerned that the children, first, this is not what the children wanted, Your Honor. If we are to look at what is in the best interest of the children, which should be the prime motivation factor here, this is not what the children wanted. The children expressed repeatedly that they wanted more time with their father, that they want to see their father and spend more time with him. But they were afraid, first of all, to say that to their mother because they were afraid that mommy would be mad. Mommy's upset. Mommy says that daddy is a bad guy. We don't think daddy's a bad guy, but, you know, mommy says that daddy took her money. And let me also say this, Your Honor. You know, the mother has relocated to Canada. How many times do you think that he's been able to speak to his children since they've been in Canada? I'll answer the question, 0. The younger boy, Nathan, had his 8-year-old birthday last month, Your Honor. He tried to contact to wish his son a happy birthday. He wasn't able to. At this point, you know, she's totally shut him out of the children's lives. That's not just, you know, a theory of prediction what may happen. That's what's going on right now. At this point, he has been totally shut out of the children's life. I also, you know, I feel even if this court were to reverse Judge Dawson's decision, I fear she would, you know, return to the United States. She's already living in another country right now. You know, at this point, she is totally shut out.
You say, excuse me, you say you're talking about things as they currently exist since the order was put into place. Has your client gone back to court and sought any kind of enforcement or modification from the trial court?
I'm not representing him at the trial court level at this point, Your Honor, but I had this discussion with him. So, you know, he may be trying to follow up with that. I don't know at this point, you know, what his plans are, but I did have that discussion with him just the other day, you know, just to find out, you know, where things are right now. But, you know, to me, if you look at the case law and if, you know, the big factor is whether the custodial parent is going to maintain meaningful contacts between the children and the father, that's not the case here. And the evidence that Judge Dawson showed that was not going to be the case. And that's, you know, not just even Dr. Ravitz, but even the children's own attorney.
Counsel, in viewing the best interest of the child as a whole, yes, fostering the relationship with the other parent, with the non-custodial parent is important, but also what is going to afford the children a life, right? Being able to support the child, put them in good schools. Now, what evidence did the father show that he had been pursuing that in order to establish that for the children. I mean, I guess my point really was he paying his support? Was he visiting the children before they left?
Okay, this case has been going on for about eight years. There were periods of time that he was unsupervised, and there were periods of time that he was supervised. I believe that the reason that he was put on supervised was because at some point he had an injury to his arm, to his tricep muscle, and he drove the kids after he was ordered not to. And the reason for that, Your Honor, was that, he was pro se at that point, which, obviously is not always the best, option, not the best scenario, but he was due to pick up the children, and the mother told him that she didn't want him to take them on the subway. So in order to maintain that visit, he drove from Queens to Manhattan to pick them up. And that, when Judge Dawson found out, that's when he was put on supervised visits.
Yeah, but I don't think you're really addressing. I don't think you're addressing the issue of that Judge Dawson believed that he wasn't providing over a period of time financial support for the children to otherwise live a lifestyle to be close to him.
Right. Well, Your Honor, in rebuttal of that, the case started right before the divorce was filed. The mother withdrew $955,000 of funds. That's still actually in dispute. The parties have not had their financial trial yet. But she started by sort of engaging in self-help to those funds. He was behind at certain points on child support, but there was evidence that he had been making substantial payments. I think there was a check in the record of $47,000.
You say he was behind at some point in time, to the extent that he was actually incarcerated for a period of time, because I think he owed $275,000 or something like that in child support. So he was not paying the child support. He was behind in the child support. And also, counsel, going to the best interest, there were other issues. I mean, there were allegations as to his use of marijuana. There was his quote unquote volatile behavior during the course of a couple of the hearings. It was questionable conduct in terms of statements that he made to the child concerning a quote unquote nickname for Judge Dawson. And so there were those concerns as well in terms of how he would, in fact, be able to relate to the children based upon the marijuana use, based upon his statements, and based upon his volatile, aggressive behavior, not to mention the fact that he was not providing any support for the children.
Well, if I could address those one at a time, Your Honor.
Well, I'm going to let you address them because but you are way over your time. So just try to address them concisely and not go on to other things.
Sure. I'll just make 2 points then. Regarding the marijuana use, that was actually specifically addressed by Dr. Rabbit, and he said, quote, "A greater concern to me than the issue of marijuana use is the possibility of the parents sharing too much information with the children," and by that he was referring to the mother as well. As far as the issues of domestic violence, Your Honors, the parties have not lived together for over 8 years now. The incidents that were alleged to have happened, some of them, the younger boy, Nathan, was not even born yet. And the other child, Eli, was either 1 or 2 years old. So I highly doubt that they would have any memory of these issues. And Dr. Rabbits talks about
Mr. Kotsky, you're frozen, sir. Mr. Kotsky. Darn. All right. Let me see if Margaret's still on. If somebody can.
I will try to reach out to him, Judge.
Thank you. We'll give this a minute or two. I'll indicate to my bench, if it's going to take a lot of time, then we'll hold off the rest of the argument till the end of the calendar because we haven't heard from the adversary. Okay, I see he's coming back online.
Hi.
All right, Mr. Kotsky, you're back with us.
I apologize.
We heard almost to the end, so final sentence, and then we'll hear from your adversary.
Okay. Basically, regarding the domestic violence issues, the children were either too young or not even born when those happened, so it really can't be a factor.
Okay, thank you. All right, let's hear from your adversary.
Good afternoon. May it please the court. My name is Michael Belmont for the respondent, Anna Levovsky. Unlike Mr. Kotsky, we do represent Ms. President or Ms. Levovsky for this purposes in the trial court, and I can represent that Mr. Levovsky has made no applications for modification or enforcement. He is a very litigious person. This is the third appeal in front of this court. And if there was anything that Mrs. Levovsky was doing, Ms. President was doing, he would undoubtedly bring an application in Supreme Court.
Well, I think more to my point, and why I asked it, is because we really can't base this appeal on what's happened since.
And I just want to touch on that briefly because Mr. Kotsky brought up current circumstances. I just want to note that it's been 2 years since the issuance of this decision, and Mr. Levovsky has not attempted to exercise visitation once. And there was a period of time when the children and Ms. Levovsky were still in New York due to COVID. They couldn't cross the border into Canada. So Mr. Levovsky had all of that time to exercise his visitation in New York, visitation under the current decision, which is greater than visitation he was afforded prior to the decision, and he just totally failed to do so. As relates to Mr. Kotsky's claim about Dr. Ravitz, I just want to note that the report was issued in May of 2016. This was, and Dr. Ravitz testified in 2016 and the beginning of 2017. This was a 3 or 4 year trial. It went all the way through, I think, middle to end of 2019. So solely relying on Dr. Ravitz's report, I mean, it's you know, the record is greater than just Dr. Ravitz's report. I just want to note that the appellant's argument is just simply asking this court to ignore the vast majority of the record of this case. The substantial record shows that the appellant was only minimally involved in the children's lives, and only when he felt like it. His claimed close and loving relationship with the children did not prevent him from refusing to pay pendente lite support for over 4 years, which left the mother and the children unable to meet monthly expenses and subjected to eviction from their apartment in New York. And as Your Honor noted, this is
and by the way, you know, just so that we're clear, because your adversary mentioned your client depleting an account, child support is not based on savings; it's based on income, right?
Absolutely.
For the most part.
Absolutely. And again, this issue has been litigated at least once in this court and many times in the trial court. And Mr. Levovsky still refused to pay support. I mean, he sat in jail for 60 days rather than provide any support for his children. In addition, as the record shows, he had no involvement in their health and wellness, no involvement in their education, no involvement in their activities. He interfered with the children's religious practices. He went 6 months in 2018 without seeing the children by his own choice because he didn't like supervised visitation. And then when he finally began to exercise the supervised visitation at the beginning of 2019, he exhibited increasingly poor parental judgment when it came to the children's physical and emotional well-being all the way through the end of trial. All of this is discussed in tremendous detail in the trial court's 61-page decision, which should be affirmed in full. Thank you.
Thank you. All right. We'll hear rebuttal. Did we lose Mr. Kotsky again? All right. We're going to just take this on submission, the rest of it. Thank you. All right, the next case up is Rustic versus 124 Bridge LLC.
If it may please the court, good afternoon, Your Honors. James Bailey for Appellant Defendant 124 Ridge. In the trial court's own decision, in addressing the liability on the breach of contract claim by the plaintiff, the court itself said, in sum and substance, it is true that there was no violation of the contract. In other words, the underlying commercial lease per se. The trial court then went on to say, however, there was a violation of the purpose and intent, in a sense, a violation of the spirit of the lease, citing to the Court of Appeals case Sutton. I do not believe it would be appropriate to interpret a contract contrary to the plain language and detailed provisions of it. By comparison, in Sutton, you had a fairly general contract, a short one, whereas here the court has a lease that's very detailed in its provisions. Indeed, the judge who decided the summary judgment motion, which was binding on the trial court, had said there were specific lease clauses that the plaintiff could in fact prove were violated and recover if in fact it could bear its burden of proof in proving that. The majority of those clauses the plaintiff did not even attempt to prove anything about. The one thing arguably that could be said was the breach of quiet enjoyment clause in the lease. That clause, if the plaintiff were to recover on it, they would have to show a constructive eviction. Now, as the court knows, there was a vacate notice that was issued. Prior to the issuance of the vacate notice, it was clear that the plaintiff, the tenant, was in fact utilizing the property and was paying its rent. After the vacate order was issued, the plaintiff was in fact not using the property. The motion court had said that a constructive eviction claim, both its standalone claim itself and as the underlying basis of the quiet enjoyment clause, could only be brought for times when the tenant was paying the rent. Now, before the vacate order, the tenant had testified, in fact, that he had paid the rent, but he was in fact still using the property, the restaurant proper.
Well,
so,
counsel, I mean, it was a little bit more complicated than what you're, leading us to believe. I mean, during this whole time, prior to the vacate order, there was ongoing construction. There was demolition of the roof and of the premises itself by your clients, right?
That is the case, Your Honor. There was construction of the building.
Right, and the construction was also the demolition of the roof of the building, and that's and then that led to the vacate order, right?
Yes, Your Honor, that is the case.
Okay, so again, based upon that, then how was the restaurant to function when this is going on and the premises are being demolished and et cetera?
Your Honor, by the plaintiff's witness's own testimony, the plaintiff was in fact using the restaurant for the lease, and this was also the plaintiff's testimony, had been to use the restaurant both as a dine-in restaurant and also for the plaintiff's other food truck business as well. So in fact,
well, because of the demolition, they could no longer use it as a dine-in restaurant. They had to use it as the truck only because of the demolition. Your clients also demolished some of their personal property on the premises, and there was an issue as to the refrigeration because they could not keep the refrigerator within the premises. They had to put it in the hall or something.
Those are essential facts, Your Honor is correct about. To prove the constructive eviction as a threshold matter, plaintiff would have to delineate the exact part of the space that it was demised, that it was constructively evicted from. And the plaintiff really didn't do that, certainly in terms of the restaurant, other than saying that the refrigerator had to be put in the hallway. And to jump ahead a bit, Your Honor, the measure of damages for that would have been an abatement of rent. That is not what the plaintiff sought to prove, nor indeed was it what the court awarded.
Let me ask you a question, because you can't get consequential damages for a constructive eviction when you have paid the rent, right? I mean, if you don't pay the rent, then you have an election of remedies, and the remedy would then be an abatement of rent. But if you've paid the rent, then it's my understanding that the law of constructive eviction would allow for consequential damages. Not so?
Your Honor, I don't read the motion court's, the summary judgment motion court's ruling as that.
I'm not talking about the ruling. I'm talking about the stated law on constructive eviction.
Your Honor, my understanding is that abatement of rent is the remedy for a constructive eviction. Even if that were not the case, we also get, of course, to the issue of damages, which was not proven at all. As to what plaintiff claimed was
not at all. I mean, there were certainly monetary consequences based upon your client's conduct, and the plaintiff proved it. May not, you know. I don't think at all. You may not like the modicum of proof that was provided, but.
Well, Your Honor, I would say the modicum was in fact insufficient because it was the bare testimonial assertion of an amount of money spent. And I think in analyzing that issue, Your Honor, it's very important that.
Isn't that a credibility issue?
Your Honor, I believe.
I can understand why your client might be concerned that they didn't provide a lot of detail, but you know, your client was present at the trial. They could have otherwise countered that, and there was nothing. It was crickets.
Your Honor, well, because I don't believe there was anything to rebut. There was no detailed testimony as to how much the build-out cost. It was just bare assertion. It cost $125,000 from a party who ought to know.
Your client physically saw the build-out.
Your Honor, I'm sure the client saw it ongoing. It doesn't mean that the client would have knowledge of the specific cost of it. I don't believe there's anything in the record showing that the landlord had participation in it. Presuming, we don't know this, I say for the sake of argument, presuming the plaintiff had hired a contractor to do the build out, the landlord wouldn't have been a party to that agreement, wouldn't have known,
Maybe yes, maybe no, maybe they would.
I understand that point.
I don't know, but okay, I understand your point, but we're going to hear from the other side now. Thank you. Respondent?
No, there was only the appellant on that one.
Oh, I'm sorry. Okay. All right. That's right. You don't even have a respondent here. Okay. Mr. Bailey, I'll let you make a final point and then we're concluded.
Quickly, Your Honor, also the finding of liability and damages on the alleged unreasonable failure to consent to an assignment. It was simply never a claim that a plaintiff had brought forward. I think I detailed that in my brief, so I will leave that with that. And finally, Your Honor, as damages are an essential element of breach of contract, the breach of contract claim wasn't proven, and I see no reason that there should be any remand for any issue of damages or any further proceedings on the case. I thank the court for its time.
Thank you.
Good day.
Thank you. You too. Thank you. All right, the next case is Queeros versus Memorial Hospital.
Good afternoon. Alan Zachary for the appellant plaintiff. May it please the court. It's respectfully submitted that plaintiff should have been granted summary judgment on his labor law 240 claim. His undisputed testimony was that he was working on a scaffold. When it moved, this caused him to fall off the side of the scaffold onto the ground. Well supported in the case law that such testimony in itself is enough to establish a violation of the statute, and that such violation was a proximate cause of the plaintiff's injuries. And that being said, if it was a proximate cause, then any failure on plaintiff's part cannot be considered the sole proximate cause of his injuries. In denying summary judgment, the motion court below relied on a written statement and a supplemental affidavit from a witness who was not disclosed in defendant's disclosures in response to a demand for the identities of all witnesses.
But you knew this person. This was the foreman, right? So you knew he existed.
Clearly,
so I'm not really. It's not like he was, as you just stated, unknown. He was known because he was the foreman.
Right. It wasn't. His existence was known, but the contents of what he would say in the statement and affidavit, that was unknown and came as a complete surprise, because defense counsel had not questioned plaintiff about whether he had been instructed or asked or anything with respect to safety railings. And there are numerous cases where affidavits submitted in similar circumstances have been rejected by this court, even though they came from, for example, a close relative of the plaintiff or someone who clearly their existence was known, but it's about what the contents.
So, counsel, to cut to the chase now, your expert stated that handrails or rails would have prevented the plaintiff from falling, right? From falling off the scaffolding. Is that correct?
If they were adequate height,
Okay. So now the foreman states that your client was instructed to put up the rails, and also had been trained previously in how to put up the rails on the scaffolding, and that your client did not do so.
He says that in very bare and conclusory ways. He doesn't identify the location of these railings. He doesn't say that he actually knows that they were there on the date of the subject incident. And the plaintiff had previously testified that he had never been responsible for assembling any of the scaffolds that he worked on.
Well, he said it wasn't his job. He didn't.
But it wasn't his job.
It wasn't his job.
And so even if you can consider the affidavit from his foreman, it qualifies as the type of affidavit that this court has consistently rejected when it's proffered for the first time in response to a motion for summary judgment, and it doesn't contain specifics. This one it's very bare. It's like it doesn't even identify a particular location that these the railings were located, or whether these railings would have fit, and if they did fit, whether they would have provided adequate protection that would have prevented plaintiff from falling.
You make an alternate argument, though. You're saying that even if there's a question of fact, even if we consider that affidavit and it raises a question of fact about whether your client should have put guardrails on the scaffolding, that you're otherwise entitled to summary judgment on 241 because there are independent reasons, causes, proximate causes for the scaffolding to fail? Am I understanding your argument correctly?
Yes, Your Honor. His testimony that the scaffold that he was provided moved, and that's what caused him to fall, independent from the issue of whether there were safety railings, has been held sufficient to establish a violation of Section 240, and that violation was the proximate cause of the plaintiff's injuries.
That scaffoldings are not supposed to move.
They're not supposed to move. And in
not
this particular
safety
instance, he
devices
was
if they
using a
move.
chipping, correct, John,
Yeah.
and he was using a chipping gun, which involved movement. So that the fact that it moved and it caused him to fall shows that it wasn't a proper device for his assigned work. So moving on to
Is
the.
there any claim that you make regarding the absence of base plates and harnesses that tee into this or tee into this 241 claim?
I believe the expert had also added in her affidavit that there were no base plates as required, and that contributed to allowing the scaffold to move back and forth, which again would be particularly inappropriate given that plaintiff had to use a chipping gun that required a lot of back and forth movement. So if the scaffold wasn't sufficiently stable, that would certainly create the risk of this type of situation happening. And the court had also dismissed plaintiff's labor law 241-6 claim, which was predicated on the violation of Industrial Code 23-5.1.
Yeah, I'm going to ask that you address that in rebuttal because you're way over your time. Okay.
Right.
Thank you. All right, let's hear from your adversary.
May it please the court, I am Martin Adams, counsel for respondents. I respectfully request that the order of the trial court insofar as appealed from be affirmed. Can your honors hear me?
Yes.
Okay, thank you. My learned attorney adversary says that the fact that the scaffold allegedly moved is undisputed. In fact, it's not a fact. On page 317 of the record, plaintiff himself was asked, did you feel kind of imbalanced prior to the accident? Answer, no, page 317. In addition, even if there was a lack of a proper protective device, and we don't claim there is, but even if there was, for the sake of argument, the sole proximate cause defense still applies. This court so held in Petrocelli. Accordingly, the trial court, and I should also add that the recalcitrant worker defense is pleaded as an affirmative defense in the answers on page 56 and 64. Therefore, plaintiff has known from day one that the recalcitrant worker defense would be applied. Now, Mr. La Barbera, the foreman for the plaintiff appellant, said that he gave an instruction and the plaintiff did not obey it, and the scaffolds were available. Now, the plaintiff can dispute that, and that's an issue for trial, as the trial court noted. However, in this case, on the record, plaintiff never submitted any testimony, any affidavit testimony, or other proof rebutting or refuting what Mr. La Barbera, the foreman, testified to in his affidavits.
Well, counsel, what about this issue that this witness, Mr. La Barbera, was not disclosed?
We didn't find out about the name of the witness until plaintiff was deposed in December 2019. And that's when the plaintiff's own counsel disclosed it in plaintiff's deposition. Plaintiff then moved for summary judgment around May or June 2020 before discovery was closed. We then first interviewed the witness, and this is all on the record, in July in order to prepare the opposition papers to the motion. Now, plaintiff's counsel could have, once the plaintiff's counsel received this affidavit, plaintiff's counsel could have asked for a continuance of his own summary judgment motion. He could have deposed the witness, could have simply taken a statement from the witness, but he didn't do any of these things. Now, the trial court did not grant summary judgment to the defendant. Here, plaintiff is seeking affirmative relief. Plaintiff is seeking liability relief on his claims for 240 and 241. And yet plaintiff's own record does not contain any factual dispute or testimony disputing the foreman's factual assertions of recalcitrant worker.
Counsel, what about the fact that they're claiming that the scaffold was defective? And there's plenty of testimony by the plaintiff on the record as to that. On page 311, he says that the scaffold was moving back and forth and that it knocked him down and that he released the pistol and stepped back in order to protect himself, but nothing was right there and he ended up falling down. The scaffold threw me backwards, is what he says. Then on 312, he says, the plywood was unlevel, uneven, and they were next to each other. stepped back with my left foot and fell. Boards moved under my feet, moved left foot backwards in effort to stabilize and fell. So in essence, even though he may have been told about the railings, it's more than just a lack of railing that the plaintiff is referring to.
Right. I'll answer that with two observations. First, even if plaintiff can show the scaffold did not provide proper protection, the recalcitrant worker defense, or simply the sole proximate cause defense, which are two different kinds of defenses, both can bar the action, as Petrocelli teaches. In addition, Your Honor, while plaintiff—
I don't know that's let me stop you on that.
That's true.
Because we have a whole legion of case law that says sole proximate cause, and I believe that recalcitrant worker is a subset of that, that if there is another cause, there can be no sole proximate cause. So I don't think that that is a clear-cut statement of law.
But I should add that while Your Honor did point out testimony from the plaintiff as to allegedly shaking of the scaffold, when further deposition, further exploration of this issue showed that plaintiff specifically denied on page 317 that he did not feel any imbalance. In addition, Your Honor, he
Well, no,
testified—
see, counsel, I think he said he did not feel any imbalance when he's standing on the scaffolding. But when he starts to perform the duty, the task assigned to him, i.e. removing the concrete, okay, this is when in doing so, it's causing the scaffolding to move forward and backwards. That's what he stated.
And what caused his fall? Plaintiff's own expert, Hopkins, testified in an affidavit in support of the motion that had the railings been erected, then the plaintiff would not have fallen. So regardless of whether the scaffold supposedly was shaking or was insufficiently stable, had railings been there, according to plaintiff's own expert, he would not have fallen. Therefore, a reasonable jury can find, based upon appellant's own proof, that he did not fall because of any insufficient protective device. And I should also note on page 317 of plaintiff's testimony, the chipping gun threw me down. Then he said the scaffold threw me backwards.
The chipping gun was part of. Go ahead.
Oh, I'm sorry.
The chipping gun had a recoil effect. That's to be expected, right? And the safety device has to sort of protect him from recoiling off the scaffold, right? No?
Yes. Well, and yes,
I mean,
and
I don't
really, yes.
I don't.
So again, it's the use of the chipping gun. It's not the chipping gun itself. It wasn't that the chipping gun, the recoil from it caused him to fall backwards. It's using the chipping gun in trying to chip away the concrete.
He said, yes, he said the chipping gun, quote, the chipping gun threw me down. No, the scaffold threw me backwards. But plaintiff's own expert, Hopkins, says if the railings were erected, plaintiff would not have fallen off the scaffold. Therefore, even if, arguendo, the scaffold did not provide proper protection, a reasonable jury can find from plaintiff's own expert that had plaintiff complied with the instruction, he would not have fallen, and he was a recalcitrant worker and therefore cannot recover. Therefore, the trial court order, I respectfully request, should be affirmed. Thank you. And I'll answer any further questions anyone has.
Thank you. Any questions, counselors? Or we'll hear rebuttal.
Just that to clarify that plaintiff's expert also clarified that had railings been installed on the scaffold as it was provided the plaintiff, they would have been too low to prevent him from falling, and that he would instead have to first install either additional scaffold tiers or posts that would make the railings high enough.
And what is that based on, counsel, in terms of the height of the rails?
It's based the expert. There's authenticated photographs of the scaffold, and that they show that the ends of the scaffold frame are not sufficiently high enough that if you put a rail on top of it, that it would be high enough on the worker's body to prevent the worker from falling over.
So your argument is not only that the scaffolding was not the proper device for purposes of this task, but also that the scaffolding was improper, because even if properly used, i.e. with the railings, it still would not have been proper in terms of chipping away the concrete.
Well, yeah, well, yes, because the defendant would have to show that the device that was provided would prevent plaintiff from falling, would protect him from the gravity-related risk. And we argue that this hasn't been shown here because even if railings were provided, it still wouldn't have been sufficient unless these additional components were added to, and there's no evidence that those were available for plaintiff to use in this instance. And then the one last point. Yes.
But that's what your expert says in her supplemental affidavit, not what she says in her original affidavit, correct?
Right. Well, at the time that she did the original affidavit, there had been no claim that safety railings were available, so she didn't have there was no reason at that point to specifically opine that they needed to be of a certain height or whether it was in direct response to things that were only raised for the first time by defendants in their opposition. And just one last point we'd like to make that as far as Labor Law 241-6, the court dismissed finding that the Industrial Code provision 23-5.1F was not sufficiently specific to support a cause of action. And we argued that this is based on outdated case law that in subsequent cases from this court and the Court of Appeals and interpreting highly similar industrial code provisions have found them to set sufficiently specific standards to support a Labor Law 241-6 claim, and the same should be done with respect to this industrial code provision here. And if there are no questions.
Any questions? Thank you. Thank you both.
Thank you. I will sign off.
Cooper versus MTA.
Good afternoon, Your Honors. Happy New Year. My name is Margaret Maslin. I represent the appellant. Friedman is the name of my client. The appeal here is quite simple. It has to do with 3 claims which have been extinguished by operation of law through a variety of milestones that have been reached in this litigation. One of those claims, it has been conceded, has been extinguished by operation of law. The relationship that is being examined on this appeal is the alleged relationship between the MTA defendants and my client, which was a product supplier that supplied the product that is alleged to have been involved in this accident to a non-party.
Yeah, so, counsel, what we're dealing with basically are the court rules. And Judge Edmead's rules specifically were that you were to make all dispositive motions within 60 days of the filing of the note of issue, right?
Yes, Your Honor, that is definitely Judge Edmead's rule. However, this case goes beyond the procedural aspect of the timeliness of summary judgment motions and goes to the way the procedure in the case regarding discovery affects.
But you waited over a year from the filing of the note of issue to move for summary judgment.
There was a lag between the note of issue being filed and the order to show cause for summary judgment being presented on behalf of my client. In the meantime, there were milestones that were reached which actually created new support for the summary dismissal of the 3 claims that are at issue on this appeal. So the MTA defendants asserted 3 cross claims, first as third-party claims, and then they were converted into cross claims when my client was sued.
Right. I understand all of that. That's not, and that's the point is, I'm sorry, go ahead.
No, go ahead. So the first claim is the contribution claim, which the MTA defendants have conceded was extinguished by virtue of my client settling out with the plaintiff. the general obligations law, section 15108.
No, I am going to stop you because here's the problem. And this goes all the way back to Brill, which is that you have a certain amount of time to make the deadline for the summary judgment. If you don't make it, then regardless of the merits, and you may have very good merits here, we don't look at that. We just don't. You have to establish good cause for not following the court's rules. So I think arguing the merits here is not really going to help you in terms of this appeal. I'll concede. It sounds like you have really good merits on your summary judgment.
But the point is that Judge Edmeade has these rules, and you violated the rules, and there was no showing of good cause for your delay. I mean, you're apparently saying, well, you weren't aware, you didn't know, but I mean, that's not a basis not to, to follow the rules. You should have known what was going on.
Your Honor, what I'm saying is that the happening of certain milestones, for instance, the settling of the case on behalf of my client and AmSafe in July of 2018 created a predicate for moving to dismiss at least one of the claims. The accident happened in 2013.
Yeah, but you didn't move then.
But you didn't, you didn't move.
You didn't do it. Great.
We did not move because there was still, to this very day, even though this is a 2014 index number, the MTA defendants still did not produce a witness for a deposition, although they produced an affidavit from an undisclosed witness in opposition to our order to show cause.
But you weren't actively pursuing it. I mean, that's what the court found. I just find that the arguments that you're making are not really addressing the reasoning of the court below. If you want to tell me that the court made a mistake in deciding that you didn't have good cause, then I think that's a viable argument on appeal. But the fact that you otherwise have good merit to your summary judgment, that law is just, it's been rejected by the Court of Appeals for years and years and years. That's how I see it.
Our position is that the court misapprehended the facts and misapplied the law in making a few determinations. First of all, that with regard to good cause, we do have good cause for the delay. And
I'm going to give you a couple of minutes because you're way over your time to tell us directly what that is. Let's hear that direct argument. What's the good cause?
The deposition of the MTA defendants was absolutely necessary to support summary dismissal of the contractual and the common law indemnity.
But you didn't attend, you didn't participate in discovery after you settled.
After we settled the case, the remaining parties, the plaintiff and the MTA defendants, the only parties remaining, acted as though
you remained too. No, you remained too. You had claims against you.
Correct. In order for the MTA defendants to pursue and enforce those claims, they would need to provide discovery. They would need to keep our client in the loop relative to.
But your client was in the loop, and there was nothing to suggest that even if these depositions had taken place, that Friedman would have participated.
The entire record having to do with our order to show cause, our supporting papers and responding papers to the opposition presented by the MTA state all over that we absolutely would have participated as we had participated in other discovery, and we absolutely would have done the same with the deposition of the MTA defendants so that we could establish through the driver that she caused the accident by stopping short, which is negligence active and separate and apart from any claims against our client. It's her negligence in operating the vehicle, which absolutely extinguishes common law indemnification. And there would have had to have been a deposition from someone like Christopher Messina, whose affidavit was submitted in opposition to our order to show cause for summary dismissal, though
Yeah, but
he had never
we
disclosed.
understand your arguments, but you didn't actively seek that either. So I think let's hear from your adversary at this point. We can't hear you, Mr. Montrose. You have to take yourself off mute. Whew.
Can you hear me now?
Yes, we can.
Okay, thank you very much. Happy New Year to all of you. You stole my thunder, but let me see if I can get a few original words in here as well. What it really comes down to is MTA's rights on the cross-claim and indemnification were still preserved. Granted, their answer was stricken. Granted, there were choices that were made as to whether or not they were going to appear at EBTs and if certain witnesses would be produced. And as you indicated through counsel before, the defendant Friedman sat on this for a whole year. Notwithstanding, let me just expand on the following. The cross claims between the defendants are still preserved. You still have to make out your prima facie case on the cross claims. And let me just expand with a couple of hypotheticals. Take an automobile case where
because the question is okay, so they don't get to go forward on the summary judgment, but ultimately they have pretty good arguments to have their claims ultimately adjudicated in their favor. No?
At the time of trial, correct. And there were cross claims. And there were cross claims between the MTA and the other defendants with regard to the ownership, the operation, the control, the manufacturing and installation of the seat that gave way. So there were a lot of issues that are floating around that will be determined at the time of trial. And the cross claims between the two defendants will be preserved. And there's also an indemnification issue, which will be determined at the time of trial. So basically all it is putting Humpty Dumpty back together again and letting all of these issues prevail and be determined at the time of trial.
Any questions, colleagues?
May I please submit a few arguments?
Of course, I gave you time to rebut to begin with, honestly, on the calendar.
Yes, I appreciate it. So letting the indemnity claims go to trial would almost certainly lead to an inconsistent verdict. The cases that the MTA cited in support of the argument that the indemnity claims are preserved despite its answer being stricken are three cases that Para, Diaz, and Paez that have to do with landlords and tenants, the relationship between absentee landlords and tenants, which is completely distinguishable from a case like this, where the MTA is being sued for its active separate negligence due to its negligent operation of the vehicle. They essentially came close to causing a rear end collision and stopped short of that. And that is the reason the plaintiff was jolted out of her seat. There is absolutely no disputing that. It's been conceded. It's all over the record in sworn
Counsel,
testimony.
did you argue this? Did you argue this to the motion court that this would lead to somehow an inconsistent result?
Yes, it is part of the argument that we made that having the answer stricken of the MTA defendants, and which means that all of plaintiff's claims, including negligence, have been summarily determined as a matter of law in her favor.
I don't understand why you can't at trial make arguments to the effect of the inconsistency. And in fact, maybe you'd be entitled to a directed verdict. I don't know that precludes that kind of disposition. I don't see the dire consequences other than that the issues that you're raising will have to be determined at the trial level at the time of trial. The trial judge will say, yes, there's something I need to take evidence on, or no, after an offer of proof, no. You just can't get summary judgment now. That's,
There's only one claim that would according to this record, be going to a jury if this appeal were to result in an affirmance, and that would be the common law negligence claim. Contribution is extinguished, it's been conceded. There is no written contract nor evidence of an intent that we would indemnify the MTA.
Okay.
So the only thing that could possibly, under any argument, go to the jury is common law indemnity. And that cannot possibly exist in a case like this where the driver caused an accident.
Yeah, I
There is
understand,
no
but that isn't really what's up on appeal before us. And if you're right, quite frankly, the MTA has to put a prima facie case in. If they can't prove it, then ding. Then you ask for directed verdict. I just don't see the dire consequences. But honestly, we have your briefs. We're going to carefully consider your arguments. And we thank you. We thank you all for your time.
Thank you, Your Honors.
Kenyan versus Kenyan against Sight Sound.
Good afternoon, Louis DeLucia for the appellant Kenyan and Kenyan. First of all, Happy New Year to everyone, and thank you all for hearing me. In addition, I commend you for your command of all these facts of 16 cases I counted before me, and I think that is incredibly
You did count
impressive.
16 cases, right? No, I think you're the 16th.
Right.
Yeah.
Well, that's pretty impressive, Your Honor. So thank you. This is an appeal, as Your Honors are aware, of basically two opinions from below Judge Maisley, one of which is a motion to dismiss a conversion claim, and the second is a trial opinion immediately just really about the entire remaining cases and remaining counts in the complaint. As Your Honors are aware, I'm sure Your Honors are aware of the facts. I am happy to address each of the facts, many of which are not disputed, but let me jump into the motion to dismiss conversion, which was not heard at trial. That was a decision by the court where the court was addressing a demand by Kenyan for the repayment of its debt, which was collateralized by certain intellectual property as well as funds that were received by the defendant, Sight Sound Technologies, and transferred to GE as a transfer that was wrongful and violative of Kenyan's security interests. Kenyan had a superior security interest, not disputed by the parties, for $5+ million of debt at that time that was and remains unpaid. And under which, pursuant to a security agreement, the debtor, the defendant, Sight Sound, was obligated, pursuant to Section 10.2 of that security agreement, to expressly segregate and hold in trust proceeds of collateral for the benefit of Kenyan and Kenyan, the secured party. They didn't do so. Instead, they transferred the funds to an affiliate, which was DMT and GE's parent, was owned by GE, and GE ultimately, who received the funds, held the funds, and applied it to an inter-corporate obligation of SST to GE. That transfer was under common law theory and the case law for conversion, an express conversion of our superior interest in that collateral. When they transferred it, which was supposed to be segregated and held in trust, express language of 10.2 of the security agreement. And Your Honor, the entire thrust of this case is very consistent with Justice Gish's opinion, where she concurred in the Modern Arts case just in 2018, where the party's contract contains no or all modification clause or broad merger language. When it contains that language, it should be not modified by extrinsic testimony or testimony that would somehow infuse language into an agreement that doesn't exist. This,
right, so in other words, yeah, I mean, that's just a general contract principle. But even the conversion claim, this all really goes back to the ultimate disputed issues that concern the trial court, which was whether that really was I mean, these were the proceeds of the Napster settlement, right?
Oh, there's no question that these were proceeds of the Napster settlement. That's correct.
All right. So doesn't this all go back to whether I know Let me just say on the conversion claim, I know that the judge dismissed it because she said it wasn't a specific identifiable fund of money for the purposes of conversion. But ultimately, that really feeds into the trial decision here, where the trial court looked at all the agreements and the what was going on with the parties, and ultimately decided that post the security agreement, that when there was an asset sale for the purposes of funding the Napster and the Apple litigation, that the manner of payout to Kenyan and Kenyan changed. It changed.
Yeah, that's right? Your Honor, let me express my view of that, which I think is essentially correct in terms of how the court thought about it.
All I'm really saying is that I think it's more important to talk about the trial decision than the conversion issue.
Absolutely, Your Honor, because I do believe that if the trial opinion is reversed, which I think it should, then the conversion count survives, and that's where I'm going. But let's talk about the trial opinion.
Okay.
The trial opinion is incorrect because A, the only basis for the court to decide that there was some sort of agreement by Kenyan to be bound to the APA, the asset purchase agreement, and there's only one provision that references that anywhere in the world, and that's Section 8A of the consent agreement. Otherwise, it's simply referenced by reference only in the consent agreement in one other provision. The Judge Maisley specifically said that at pages 5 to 6 of the motion to dismiss opinion. So that's the only place in the world. And if you look at 8 and you read the express language of the contract, it says Kenyan has the option, Kenyan has it, to either take payment of such obligations or B, elect to take a participation pursuant to 7.2C of the APA. It never elected. Judge Maisley even opined that in her opinion.
Right. They never elected, so they're under the first provision, right?
That's payment in full. And so the only place, and that's payment in full, is the only other first.
By who?
By Sight Sound.
But Sight Sound doesn't get money until under the APA until like the third tier.
It doesn't get money under the APA, Your Honor. It doesn't get money from the APA. It gets money from a litigation, a settlement agreement in 2012 from Napster litigation, which actually Kenyan began working on and incurred the fees for. So the litigation was begun prior to the APA, continued throughout the APA, and is simply the recovery of a settlement of litigation. It is not proceeds of revenue. The revenue that is referred to in 7.2C and is painstakingly drafted by Paul Weiss throughout this document is revenue with a capital R that refers exclusively to license agreements. License agreements do not include, by their own definition, settlement agreements, which is defined in the APA. In fact, the settlement agreement is defined in the APA to expressly exclude, if you look at the definition in section 1.1, any license agreements, i.e., 7.2C does not apply to the Napster proceeds, period. That's a contractual reading of the document. The judge's reading extrinsically or taking of testimony extrinsically about what people thought afterwards or what a PowerPoint was related to by an internal presentation at Kenyan explaining what the options would be had Kenyan accepted the option, which it never did, is not relevant. The contract expressly states what it states. We did not agree to the option. 7.2C was thus inapplicable to Kenyan, even if it were, the express contractual language of the security agreement, the consent agreement, the amended consent agreement clearly state Kenyan elected to be paid in full, not the 10% option, which gets us to 7.2C. 7.2C, when you read it, expressly applies to revenues, capital R. It is expressed, that definition, Your Honor, is even carried through carefully by Paul Weiss into paragraph 8A of the at record 297 of the consent agreement, where the election to receive in perpetuity 10% of any revenues with a capital R. Then when you go to settlement agreements in the APA, it refers to revenues without a capital R of recoveries of settlement agreements, which expressly exclude license agreements. Now, knowing from trial and knowing what my learned adversary will say, is that the license agreement, that revenues references section 3.1 of the in the APA. Section 3.1 of the APA is referenced in revenues because it even supports my agreement twice as much. It expressly says that any DMT site sound internal license agreements are excluded from revenues. That's why 3.1 is referenced, not for the reason my adversary will express. It is a misreading of the document to suggest otherwise. Look at the second half of section 3.1 and the language used there to exclude internal DMT site sound license agreements from revenues. So, Your Honor, this is a case where if you really look at the contracts and you look at the secured party rights and you enforce those rights, you're going to see that the testimony regarding delay, which was completely not only irrelevant as a matter of law, which this court has the ability to discard, because number one, we had the rights expressly under the site sound security agreement. There was a provision that said there was a waiver, no waiver of any rights of Kenyan by delay.
The court's decision wasn't based on a waiver.
It was laid on delay.
She was interpreting the contract. She didn't say that you waived your right by not asserting it. She did say that the failure to assert was consistent with the fact that everybody understood what she thought were ambiguous provisions of the agreement in a certain way. So I don't think waiver, I think that's off base.
All right, let's go back. Well, course of conduct, the section of the security agreement expressly says no waiver, meaning including caused by delay of course of conduct. So that's number one. Number two, it isn't consistent because she factually misses in the opinion, as testified to at page 833 of the record by Mr. Lepore, a defendant witness, that Kenyan made a demand for the payment in June 29th, 2012, after receipt by GE of Kenyan's collateral, expressly made the demand. So there was no delay. So she's factually wrong. Okay. So you wonder, there are so many errors with this opinion, not only factually, but legally. It is, if this court finds that we were wrong somehow in Kenyan's conduct, the court would have to find that despite the express language of a security interest and consent agreements and amended consent agreements that preserve the secured parties' rights, where the parties all agreed that the collateral and property were taken subject to our rights, that by simply not acting within the statute of limitations, which we did act within the statute of limitations, meaning commence a lawsuit, somehow causes an interpretation of the contract to say that we were subordinating our rights, where there's no language. The word subordination doesn't exist in any of these contracts, nowhere. It is a convoluted interpretation of section 7.2 exclusively. They get the argument that we subordinated. It's wrong legally, it's wrong factually, and we should have this decision reversed.
Okay, let me hear from your adversary.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. May it please the court, Brian Whelan for respondents. There are two telling things, at least from counsel's argument. First, focusing on the conversion count to start, they don't want to talk about the trial decision, where the court for over 30 pages assessed the credibility of all the witnesses, citing to all the testimony and evidence on the record, finding sight sound defendants and GE's witnesses credible, and finding Kenyans, with the exception of one who authored that, quote, damning PowerPoint, that their own internal PowerPoint defined the agreements exactly as we say they are, and as the court ultimately found their witnesses not credible. But second is, they always talk about the security agreement, but they'll never talk about what came after, and that's the 2005 consent agreement. They consented to the asset purchase agreement, which was attached, and the transactions contemplated therein, a sale, a defined term. And one of those transactions was this allocation of revenues post-closing. And there is a waterfall, and it first goes to DMT to refund its expenses. Kenya did this for two really good reasons. The first reason is that absent the litigations continuing. So in 2005, Kenyan
Right,
organization.
they were, the Sight Sound was out of dough. They couldn't keep the litigations up. They needed to finance the litigation. And there was, actually, it was a surprise to me to read this. It looked like they were very good litigations, right? That they were going to yield something good, you know?
Absolutely, Your Honor.
But they didn't.
Well, so they first did, and then the first couple did, and then the big one, which was against Apple, ultimately did not materialize the way it wanted. But let's assume for a moment it did. Okay, and now we're talking. This was expected to be hundreds of millions of dollars for at least for the Apple litigation. Would Kenyan not be taking its hand out and saying, "I want 10% of that," which would have been a multiple of their fees? Or would they be making this argument that counsel's concocting now, that somehow, no, it was just licensing agreements, not settling agreements? Common sense dictates everyone understood it. And by the way, that's what the contract says. It says subject to 3.1, not just license agreements, which says that we have that DMT had the right to exploit the patents by also commencing these litigations. It is not just license agreements. Their own expert said that a litigation settlement can be considered licensing revenues. So that's just a concocted argument. And Your Honor said it correctly. This is not about waiver. The court on summary judgment found an ambiguity in the consent agreement. Well settled New York law. Once that happens, we look at all the course of performance. And this was not a close call.
And the ambiguity that you found was the reference to the APA that was attached to the consent agreement.
I would say it as the scope of what they consented to. Kenyan tried to argue, oh, no, we just consented to the actual transfer of the patents, not anything else in the APA. But it says, I would argue, it says, of course, it says transactions, a plural term, contemplated by the APA, which again was attached. But yes, Your Honor, found an ambiguity into the scope of the consent, held a trial, and, quote, overwhelmingly indicates from the closing table of the transaction where the specific issue came up, Sight Sound's witness said this issue came up and they relented on being paid first. Mr. Tobin, who was at the closing table, also testified, acknowledged the meeting, and never refuted that testimony. Never refuted it. Then you've got the internal PowerPoint, which the trial court found damning, which explicitly says DMT gets paid first. And of course, the court's saying, why would that be part of this if in fact it was the other way? And then finally, Your Honor, 16 months, they get an email saying, we got $3.1 million from the Napster settlement. We got, it's going to DMT. In it, writing, in an email, and no response, no claim for 16 months. This notion about a letter after the fact is respectfully disingenuous because it says nothing that they're entitled to the Napster payment. What it says is they're asking for the entirety of the debt. They never made this claim for 16 months until outside counsel got in the mix. And even if there's also an email from Mr. Colbert, an attorney at Kenyan to a potential outside counsel saying, is there any way to reach that money? Is that believing that they're entitled to the money? Of course not. So all of the evidence from the start of the closing to all the relevant events show only one conclusion, which the trial court found overwhelmingly indicates that the parties agreed that DMT would be paid these funds first. And so for those reasons, Your Honor, unless there's any questions, we stand on our papers and the trial decision and the summary judgment decision on the conversion account should be affirmed.
Any questions, colleagues? Okay, we'll have some rebuttal.
Thank you, Your Honor. Very briefly, the issue of ambiguity, assuming there is ambiguity, is as a matter of law something this court has the ability to revisit as to whether or not there even is ambiguity. As Your Honors are aware, that is the purview of this court. I don't believe there is, and we certainly give you the authority, but I know you know it. I certainly am aware that the defendants argue hereof, the word hereof, which obviously refers, in my view, to the consent agreement plainly, because it's referring in the consent agreement hereof, and because the APA is attached by reference, that's the express language, for reference is the express language of the document, doesn't mean that it is incorporated or bound, but that doesn't matter because this court has the authority to and should read the strict language of the contract. It doesn't say what the defendants propose that it says. It simply doesn't. And the suggestion that somehow Kenyan agreed to subordinate its security agreement, even if the ambiguity is decided, the only thing the ambiguity is deciding, the only thing, is whether Kenyan was bound to the APA. Assume it was. Section 7.2 and the consent agreement and the amended consent agreement, which was done in December 2011, just months before the fraudulent transfer and the diversion of our collateral, was done, and it expressly states in the whereas clause, Kenyan has elected to be paid in full. Says it in the whereas clause of the amended consent agreement. Then 6 months later, they transfer the funds to GE and pay themselves back. There is an inequity into reading this document the way they want to. It is simply wrong. And what the argument is that somehow that language should be turned around and interpreted in a way. My adversary interpreted section 3.1 in a way that it isn't written. You'd have to speak a different language to understand it the way he did. 3.1 expressly states that the only reason it's here is because we are excluding franchise agreements that are intercompany from revenues. It's consistent with what I've said before. Revenues do not include, and that's the only thing 7.2 addresses, is revenues. So there's no way that even if, because it's the only section, by the way, not the rest of the APA. The rest of the APA is literally irrelevant. 7.2 is the only section they cite. And that section only applies to revenues. And it only applies to franchise agreements. Now, if you look at the May 4th, 2012 email from Mr. Lepore that expressly says we received the settlement proceeds from Napster pursuant to a settlement agreement. It says pursuant to a settlement agreement expressly in the documents. I think it's in the record. I don't remember the exact page, but it's in the record. I can get it for you. That record expressly states that the funds were received as a settlement payment. You look at the APA settlement agreement specifically defined in section 101 to exclude licensing agreements. So whatever counsel says is a misinterpretation of the document that is express. It would be wrong for this court to decide any other way. The ambiguity and the inaction of delay really means nothing because there was no delay. There is admitted testimony. Somehow counsel suggests that demanding payment in full of the $10 million obligation is less than demanding the $3.1 million that was fraudulently conveyed. I don't understand that. We demanded $10.1 million, not just the 3.1. He's using the inverse argument to suggest because we asked for more, somehow we didn't ask for the less. That is illogical. June of 2012, we demanded it.
Yeah, I'm going to ask you to wrap up your argument.
Thank you, Your Honor. As you can tell, Your Honor, I've lived this for years. I am passionate about this cause. I believe it is correct to my core, and I implore this court to decide for the right.
All right. Thank you. Thank both of you for your arguments and for your patience in waiting till the end of the calendar. This session of the Appellate Division is now closed.
Thank you, Your Honor, very much, and have a good day.
You too.
Thank you.